Well, good morning, everybody. Everybody here has probably heard this before, but I'm told I've got to do a health and safety briefing each morning. So the doors, if you come in, the toilets are outside there. That's the exit. Immediately, if we have an emergency, earthquake, fire, or anything, we need a space bail house, which is a really appropriate place. And, otherwise, cell phones off. And as I said yesterday, having noted that some Otago people and Southland people appeared at a select committee and were horrified to find that the people on the select committee were A, not present, were on Zoom, and the members of Parliament, and B, were actually looking at their cell phones through most of the presentation, and some of them confessed that they were texting. We will be looking, or I will be, others may be, looking at our cell phones. We're not texting. I'm not texting. I'm looking at topo maps or the RMA. So, but I do ask you to make sure your cell phones are off and do not text during the presentation. With those opening comments, welcome to Manawa again. And we had a very long day yesterday where Mr. Keesing, or Dr. Is it Dr. or Mr. Doctor? Yep. Dr. Keesing was questioned by us. So for the Manawa representatives here, if we don't bother too much with Dr. Keesing today, it's not because we're not listening to him. We found this evidence very interesting, but we've had to go with it.
So your microphone thingy was flashing an orange light,
right? Okay,
and then it turned off.
right.
So
Thank you. Well, look, I hope that you heard all that anyway.
we did, but
Good.
your battery might.
Battery's fresh.
What's it?
The batteries are all new.
All right.
But the microphones are only so the people at the back of the room can hear. These microphones are for the Zoom anyway. So.
Oh, okay.
Okay. So we're in your hands. Thank you.
Thank you. Tēnā tātou katoa. My name is Lara Burkhardt. I'm the legal counsel for Manawa Energy Limited. We're all in person today. There's nobody virtual. To my right is Nicola Foran, the Environmental Policy Manager, with whom I'm sure you're familiar from the Energy and Infrastructure hearing in March that unfortunately I wasn't able to attend. And then to my left, Stephanie O'Sullivan, Manawa Planning Consultant. Stephanie O'Sullivan is another planner. Stephanie Stiles, my apologies, Manawa's Planning Consultant. Again, you've heard from her in relation to this RPS matter, and Dr. Vaughan Keesing, who we have not given a leave pass to. And he is here today to address anything that might have come up overnight. Certainly for me, something came up for me overnight, and I believe there's a correction to the track change version of his recommended changes to Appendix 4, and I'll ask him to talk to that when it's the appropriate time. So he's got something small to say at least, if it's only a typographical correction. So I presented, well, I tabled at the Energy Infrastructure hearing legal submissions that did cover in an overall sense Manawa's interests. Then went on to address specifically that topic. I did signal there in those submissions that I'd prepare some additional submissions for this hearing because it's topic based. So I've had circulated, and you should have that now, some brief submissions in terms of the eco chapter provisions. So my proposal is to take you through those in the usual way. So as I said, these submissions are to be read alongside the legal submissions table for the Energy and Infrastructure chapter. Those submissions introduce Manawa and the reasons for its interest and involvement in Otago, and introduce Manawa's company and planning witnesses who also appear today. And while Ms. Foran does appear today, she's not proposing to address you further unless there was something that you had a specific question around. In relation to the eco topic, Manawa has collaborated with Contact Energy, as you're aware, and Dr. Vaughan Keesing provided ecological assistance and evidence on behalf of both generators. And in relation to the differences, In terms of Manawa, the Manawan contact, common evidence relates really to the eco chapters, and where Dr. Keesing went further for contact was really in relation to the land and freshwater provisions on which Manawa didn't have submission points. So, but in terms of where there's evidence in common, it's largely the same, if not identical. And I apologise if that did cause any confusion for the panel. We did contemplate providing one single brief, but then that potentially became confusing if throughout it we had to say, well, this is up behind, only on behalf of one or the other. So that's why they were split over two. So in these submissions, I'll explain Manawa's overall position. I'll identify the relief and remaining areas of disagreement following the joint witness conferencing, and I'll address just a couple of legal issues that's in relation to the relevance of the draft NPS for biodiversity and the section 32 analysis for the significance criteria in Appendix 2. So put simply, the position of Manawa is that the eco chapter is overly conservative. It sets too low a threshold for protection. It takes a no effects approach to ecological areas, an approach which appears to apply regardless of the level of significance or values of natural areas or the type of activity that is being considered. The criteria for determining SNAs sets a low threshold for significance, and their application is likely to result in large swathes of the region being identified as significant. And Dr. Keesing explains, as I summarise in my paragraph 5, that the assumption underlying the proposed approach to Indigenous biodiversity, that it is rare or under imminent threat of loss, is not correct. Instead, he says that the RPS approach may prove obstructive to biological gains and put the future of biodiversity in the region outside of the conservation state and other large-scale protection lands significantly at risk. He explains that while it is desirable to continue to reduce Indigenous biological diversity loss, it is not desirable to do so at any cost, especially by preventing options that may deliver biodiversity benefits. This is especially so when the proposed RPS also recognises that restoration and enhancement are required pathways to attaining more Indigenous biodiversity. He also explains that climate change will lead to a fundamental exacerbation of the current rate of loss of Indigenous biodiversity, and addressing this requires prioritisation of reduction of greenhouse gas emissions and the enhancement of the resilience of our biodiversity, Indigenous biodiversity. He says, however, the proposed RPS works against this by precluding renewable electricity generation projects that could deliver overall biodiversity outcomes for the region and for the country. If the proposed approach to managing effects on ecological areas is retained, in my submission, the result is that it will be extremely difficult to maintain, upgrade, or establish new renewable electricity in Otago. This is inconsistent with the National Policy Statement for Renewable Electricity Generation. Lastly, I note that the interaction of the eco policies is not clear, and it needs to be. Sometimes explanatory text or more words are used to guide readers, which in my submission could assist here in places. So in terms of the relief in the areas of disagreement, I've listed there the policies, methods and appendices on which Manawa has submission points. I've noted there that in relation to the Eco Policy 4, the reporting officer has recommended to accept the addition that Manawa's submission point sought, and that resolves that policy for Manawa. So in terms of the remaining submissions and provisions, I've started with Eco Policy 5, which relates and provides a pathway for existing lawfully established activities within SNAs that may adversely affect Indigenous species and ecosystems that are taupa. Manawa sought amendments to Policy 5 that better provide for minor upgrades, and the officer recommended accepting that reference to minor upgrades, as well as the continuation and maintenance of existing activities, but considered it important that the parameters in Clause 1 and 2 were still met. Manawa actually also sought changes to Clause 2 to require that the effects be the same or similar in character, spatial extent, intensity, or scale, rather than being no greater, which is what the policy presently provides for. And I did note that the officer didn't refer to that relief in the report, but in her opening statement yesterday, she did respond to that. And I've set out in my paragraph 12 what that response was. I'm not going to read it out. With respect, though, I found the reasoning of the officer difficult to follow. If the proposed activity is not considered a minor upgrade, then in the case of Manawa, it will likely be dealt with as a new activity under Eco Policy 4 as regionally significant infrastructure, to which Eco Policy 3 does not apply. Rather, the effects management hierarchy provided for in Policy E6 applies. In terms of the relief sought, Ms. Stiles' opinion is that the word same or similar is a more generally understood resource management term and is more appropriate than no greater. The effects cannot be more significant because to fall within the application of the policy, they must be the same or similar. In my submission, it's generally preferable to adopt understood and often applied concepts rather than introducing new ones that are not frequently applied and so are not supported by a body of case law. Simply as a matter of sense, it's difficult to see how effects can be no greater in character, whereas using same or similar makes sense in the clause and provides for a comparative assessment of the nature of effects as well as their magnitude. And as arose in discussion yesterday, is in line with the kind of language that you see around the existing use rights provisions. In terms of Policy 6, that requires the application of an effects management hierarchy for Indigenous biodiversity. It requires avoidance of effects on all Indigenous biodiversity as the first priority, and then to mitigate, offset, or compensate for any residual effects. In other words, all effects on biodiversity must be addressed, and this applies regardless of the significance of the biodiversity. So equally to a high value area of native trees as to a low value area. Ms. Stiles explains in her evidence that the way the policy is currently worded means that it leads to a no adverse effects expectation, as it requires applications to avoid, remedy, mitigate, offset, and compensate. And if all effects cannot be managed through this hierarchy, then it defaults back to avoid. Read alongside the offsetting and compensation appendices, which say that these are not management options for vulnerable biodiversity. If a project would have any residual effects on vulnerable biodiversity, it cannot proceed. This exclusion is strongly opposed for the reasons outlined in the evidence, and in my submission, the approach, which is essentially to stop in its tracks any proposal that might affect biodiversity that is considered vulnerable, and where that is not, and where that term is not defined, let alone identified and mapped, isn't appropriate. An approach of having a specific provision which provides a little bit more flexibility for important types of activities that need to be better enabled is entirely appropriate in my submission and consistent with other policy direction at both a national and regional level. Both the NPS for freshwater management and the draft NPS for Indigenous biodiversity, for example, take that approach. In fact, the NPS freshwater was only recently amended to provide even greater flexibility after the significant implications of its approach became apparent. This highlights the need to take utmost care to ensure that the implications of conservative and directive policies are properly understood and evaluated before including them in the RPS. The reporting officer acknowledges that the biodiversity effects management hierarchy is more stringent than the effects management hierarchy contained in the land and freshwater chapter. The application of an effects management hierarchy to Indigenous biodiversity is not directed by any operative national policy statement. Notwithstanding this, it appears though as the officer is recommending the rejection of submission points based on it being a policy that stands on its own, and so a deviation from it is not possible. With respect, the blanket application of the effects management hierarchy in the way proposed is simply a policy decision of the Regional Council. Given how restrictive it is, in my submission, a careful analysis of the approach under section 32 is required, and this has not been sufficiently done. The implications are likely to be significant and in some instances inconsistent with what is national direction under the National Policy Statement for Renewable Electricity Generation. One way of addressing this is, as Manawa has suggested, being the limitation of the effects management hierarchy for Indigenous biodiversity to significant adverse effects. Per the evidence of Dr. Keesing, minor or less than minor adverse effects should not necessitate management. And notably, the council for the Regional Council appears to agree with Dr. Keesing, supporting an amendment to avoid any doubt. I picked that up on in the submissions that I was able to obtain a copy of yesterday. I understand that council for the mining companies yesterday raised an interesting point in relation to 104.1ab. I agree that on its face, the subsection appears to limit the ability for plans to remove from consideration offsets and compensation entirely. In saying that, I also recognise that in many situations throughout the country, policy direction, including at a national level, does appear to conflict with this requirement. For example, where a policy directs the avoidance of effects and leaves no room for anything else, then offsetting and compensation are not available considerations. Section 104.1ab would still, however, apply to any other positive effects of the activity, and I'd add to that, or where there isn't otherwise an effects management hierarchy, like the one being proposed through this policy statement. Take a breath because I've been reading very fast, just to give everyone a break from my voice. So I'll move to methods. Methods, ECO, M4 and M5 direct regional and district plans to require that no resource consents be granted unless the sequential steps in policy 6 have been followed. Manawa's submission was that it is inappropriate for an RPS to state circumstances in which a consent application must be declined, with that being a matter that should be determined through the appropriate RMA process. Ms. Stiles provides expert evidence that in her opinion, the implementation of the methods will require declined or prohibited activity status where the effects management hierarchy is not followed. This, in her view, is not something the proposed RPS should direct. Rather, there should be more flexibility provided for in lower order planning documents. This is particularly so given the application of the effects management hierarchy as a means of achieving the objectives and policies may well be too simplistic an approach, and in her opinion, this directive aspect of the method should be deleted. The officer does not recommend accepting the submission to delete clause 2b because it does not make the decision on the resource consent applications. It provides a policy framework for lower order plans, and the officer says it is for the decision maker to decide what weight to give a policy. The degree of flexibility to be provided by a provision in an RPS must be a matter considered at the stage at which it is proposed. So here, while these methods do not make the decision on consent applications, which they cannot do as a matter of law, the method of implementing them is clear: direction in regional and district plans to decline and/or prohibited activity status. In my submission, the panel needs to consider and decide first as to whether that is an appropriate approach for this RPS to take, and secondly, whether it's the most appropriate way to achieve the objectives, having regard to the matters set out in section 32. In light of Dr. Keesing's evidence that a linear hierarchy of sequential steps for the entire system can reduce or limit the potential for ecological benefits, such an inflexible and directive approach in my submission should be avoided. Turning to the appendices, Appendix 2, the experts, the ecological experts have participated in joint witness conferencing, which has helpfully narrowed the issues and identified the outstanding areas of agreement in relation to Appendix 2. I've summarised in my paragraph 32 the areas of disagreement in relation to the criteria that are relevant to Manawa's case. and I'll go through them. The number of criteria that need to be met before an area is considered to be a significant natural area, where only one criterion needs to be met. So the question is, or the matter of disagreement is, whether only one criterion needs to be met, or as Dr. Keesing suggests, whether the more appropriate approach is to categorise biodiversity as significant where it meets the rarity condition, or two or more of the other criteria. Several of the experts acknowledge that meeting only one of the criteria is a low threshold for significance. The other matter of disagreement is whether the rarity criterion should have a regional or national focus. Thirdly, whether the criterion for diversity is required, or, as Dr. Keesing outlines, is redundant. Whether the distributional limits are relevant or a reasonable ecological consideration and distinctiveness, and the role wetlands play as an important hydrological or ecological role in the ecological context criterion. That was a mouthful. All experts have agreed that the vulnerability criterion should be deleted. Dr. Keesing yesterday took the panel through the key outcomes of the joint witness conferencing with a focus on the remaining areas of disagreement, which I've just summarised. I think if you line up the two-page summary that he gave yesterday, he's tried to connect his view on those outstanding points to the ones that I've summarised, and he's available today in the event any further questions arise, and to make a typographical correction to his evidence when the time comes. In terms of Appendix 3 and 4, Dr. Keesing raises a number of concerns with the clauses, and I note that those appendices were not the subject of comp printing, it was only Appendix 2. The primary concern with the appendices that define the approach to offsetting and compensation is the clause that says offsetting and compensation is not available for irreplaceable or vulnerable biodiversity. That and those terms are not defined. This approach is different to that taken in the exposure draft of the NPS IB, with vulnerability as an example rather than as a test. As discussed above, this is a potentially significant impediment to activities in the region and needs to be carefully evaluated. So there's only two legal matters I wanted to briefly address, and that's the relevance of the exposure draft of the NPSIB and whether or not the implications of implementing the Appendix 2 criteria are relevant under Section 32. In terms of the draft NPS, the Council's legal submissions that the draft NPS has no legal standing is supported. There is no statutory direction to give effect to it at this point. In my submission, the panel can take the draft NPS into account, but will need to exercise some real care in doing so. It is still going through its process. The draft NPS may be relevant to the panel's consideration to the extent that it reflects or is consistent with the ecological evidence from experts before this panel, and so reflects best practice in the assessment and management of effects of Indigenous biodiversity. In terms of the Section 32 analysis, the ecological witnesses, at least some of them, agreed that the implications of implementing the criteria have not been assessed under Section 32 or within the 42A reports. Several of the experts noted that they do not consider it relevant. For completeness, I note that the proposed criteria are provisions in the proposed RPS and are subject to Section 32 as a legal requirement. There are a range of expert opinions on the criteria, and so this is not a case of adopting an industry-wide or generally accepted technical approach to determining significance, nor is the approach to significance in the policy framework that applies alongside it the subject of operative national direction that must be given effect to. The potential implications of the criteria and the framework within which it sits, in my submission, need to be fully assessed under Section 32. Thank you.
Thank you, Ms. Baker. and maybe questions.
No, thank you. Found the legal submissions really helpful. So I'm just going through everything point in here. I'm assuming in relation to your paragraph 22, where you talk about section 1041 AB, I'm assuming that there's no case law around that option that would have been raised with us if there was anything, any useful guidance out of the courts.
No, I'm not aware of any.
Yeah, okay. Yeah,
But like I said, it's an interesting submission point, and I can see why on its face it can be one that's made, but equally, I think you have to recognise that there are avoid policies that don't even allow you to get to biodiversity and offsetting, and I don't know that 1041A gets you there in the absence.
yeah. Yeah, no, thank you for that.
Thank you. Probably not related to what you've just addressed on, but section 6C pretty much deals with significant stuff. And then we have the functions that have been added into regional and district councils, which seeks to maintain Indigenous biodiversity. And when I look at this structure of this thing, I think this is probably where Dr. Keeson is heading as well, is that it seems to elevate all Indigenous biodiversity up to section 6C almost. I'm not sure if I'm right about that, but I'm interested in your legal opinion of how those two relate. I think we heard from yesterday that maintain means protect. So in that context, council has a function to protect all Indigenous vegetation regardless of its significance. Is that how you see the Act working? Or?
It sits in the functions, which is a different part to the Act. I don't read whilst maintained might mean protect in some circumstances. I don't believe it could mean that in all circumstances. And if all biodiversity was meant to be a section 6 matter rather than significant, it would be.
Yeah, that was, I was going to follow on with that, because if they'd made that change in the functions, surely it should have been recognised in at least section 7.
I mean, the local authorities, regional councils, city district councils have a range of functions that will need to be considered along with the national direction that you're required to give effect to. So there isn't, I don't believe it's an appropriate case in light of all of the relevant matters to take an absolute protect approach to all biodiversity. To look and take into account the particular activities that are the subject of the assessment of effects. And in our particular case, or in Mana's particular case, those activities are treated specially through having their own national policy statement, which must be given effect to. It needs to be balanced against those functions to maintain biodiversity. I've probably gone too far for that, so my apologies.
No, that's fine. Your paragraph 6, you talked about managing the effects and ensuring the current Manawa's current projects or activities in the Otago to maintain, upgrade, etc. Saying it'd be extremely difficult. I'm wondering, and it may be a question for this forum, if you could put that in the context of an example, how this policy framework would impact now.
So can you say the first part of that question?
So the paragraph 6 talks about if this framework is maintained, the result would be extremely difficult to maintain, upgrade, or establish new AEGs in Otago. In the context of existing activities now in Otago, do you have an example of how that framework would curtail the maintenance? of
Yeah,
that?
so where we bump into this with our existing operations is more on those sort of ancillary type activities that we might need to undertake from time to time to facilitate a maintenance activity. And it's often things like the transport roads. So we have a lot of
Yeah.
tracks and things through Indigenous biodiversity. And if we would need to say do something at a station that might require an oversized load, for example, to get through, there might be like vegetation trimming or road track realignment. There might be a sharp bend that the truck can't get through. It's those sorts of activities that we often will end up getting a consent for to facilitate what's sort of operation maintenance in the sort of general
Yeah.
sense. Yeah.
So does Eco P5 not provide for that?
Deflect to Stephanie.
Yeah, sorry.
It's like pass the parcel, isn't it? The answer is it depends. So it depends on the circumstance and the scale of what's needed to be done. So the existing activities, obviously, in these existing schemes are lawfully established, and it's around that operation and maintenance, the clearance of the routes or the ability to get things through, or around stations and races and the facilities where Indigenous vegetation starts encroaching over time and needs to be cleared to give the access and to do repairs that happen with weather events and those kind of things. And it's going to come down to how the wording within this policy is then applied to lower order documents around those things, like not leading to the loss of extent or degradation and no greater in character. And they're very absolute kind of terms that could make it difficult, depending on interpretation, when you get down to rules and plans that could say no clearance of vegetation or very limited clearance when you've got quite big areas that are needed to access or maintain through these facilities. Some of them, the race for structures and systems with somewhere like Waipori are linear kilometres of things, and in environments where you've got native vegetation coming through over time.
Yeah, that's the issue here, because it keeps growing.
Yeah.
And it might not have been there.
No, and how far this goes in terms of that existing use concept of things when you've got, again, Eco P6, which appears to require protection of all Indigenous biodiversity regardless of its value.
Because I understand what P5 is about, but almost why wouldn't you leave it to existing use rights? Because if it's already established, it's already got an existing use right timeframe in play. This is sort of coming in over the top of that
Almost redefining
Yeah.
but using different words, and you're left wondering, is it meant to be something different or not?
Sorry, I know this is meant to be legal submission questions. Yeah, thank you for that. Probably don't have to ask any more questions of you now, Ms. Thomas. I don't think I had anything else, actually. Oh, it's probably only in the context of what Mr. Christensen raised about that, and I think you've dealt with it 1041A or 1B or whatever it is. The way I thought he was saying is that, well, the plan can't stop you promoting other options around that to put in front of the consent decision maker. But I'll leave that. Thank you.
Yeah, I'm not sure that they can stop an applicant putting it forward, but it might have been a decision maker giving too much regard to it if there's a clear policy direction that
Yeah,
cuts off that. And certainly it applies wider than to address effects that aren't the subject of an effects management hierarchy, including particularly positive effects.
thank you.
Probably the example that I would give you, and you've heard from this forum's styles, would be potentially around a dam safety type upgrade. For which there could be some existing use rights potentially, but it would depend on whether or not that upgrade fell within or outside the minor upgrade. But if you end up in policy 6, the limitations and the appendices, and this is what Dr. Keesing talks about, you're almost given with one hand a pathway and then it's taken away through the limitations. And if you circle back in policy 6 to avoid, that's where you circle back to. And I think that's where it can bite in terms of affecting existing activities.
That dam example was quite relevant too, not just for energy generators, irrigation. There's a lot of irrigation infrastructure and they're very old dams in Australia. There's a lot of work that needs to be done on those. I think the dam legislation is being updated recently. It makes it a hell of a lot more difficult to comply. So there's a lot of upgrading work going to come, I think. Yeah, thank you.
I'm not a lawyer, but I do often seek to get some real clarity on how things are defined. And one of them is the word tauka, its use. Eco P5 refers to indigenous species and ecosystems that are tauka. Yeah, you could read that a number of ways. I read it in 2 different ways. It says that only those indigenous species and ecosystems that are tauka are included, or that all indigenous species and ecosystems are tauka. You get the difference that so some are and some aren't in one context. The other context is they all are. So, and in the second context, you'd almost not need to use the word tauka. You just take that as a given. Is that the way you interpret that? Like that Eco P5 wording, or how do you define it?
No, I don't think I disagree with you on that. Because I'm from the North Island, I assume tauko is taonga.
Yes, it is tauka. Yeah. Even I struggle sometimes to say tauka, but that's just my shortcoming.
Yeah.
Well, one of the reasons let me just expand a wee bit. One of the reasons why I'm so focused on that is to do with the question of how mana whenua, how ngaitahu is brought into some of these discussions in a more meaningful way. Often these discussions are had without any direct input, or may look for some sort of response from them. And it's through use of Māori words like tauka that I'd expect mana whenua to have a bit more of a, I'm not saying it's not just you, but it's a kind of general question I look at power generator or any other interests in the local area. Looking, I suppose, more and particularly as to how closely involved they might or might not involve Ngāi or Kaito in whatever planning or discussions you're having. And that's why words like tāka are important. I mean, I go back to your own name, Manawa, for example. I mean, you got it from the local hapu, right? They get that. So those things in my mind are real, they're meaningful, they're important, and they need to be illustrated in any number of ways that the rest of the world can see, I suppose. And that's why I raised this question. And there's I guess there's an institutional ethic here that I'm kind of looking for. How does Manawa deal with that broad issue that I'm struggling with a bit at the moment?
It's a big question. I'll sort of unpick it in a few different ways, or try and address, not unpick it, my apologies, address it in a few different ways. So use of Māori terms is important, and beyond the provisions that are subject of Manawa submissions, my read is that there is a significant opportunity written into the plan for Ngāi Tahu to work with the regional council. And in fact, the mandatory requirements for local authorities to work with Ngāi Tahu in relation to that issue of identification and then assessment and then management of impacts on taupa. I think it's a very strong policy framework for Ngāi Tahu, and it's certainly an approach that is more prevalent across all sorts of regions and districts in the country. Historically, I'm sort of thinking 10 years ago, you might have a bespoke chapter, cultural matters. You wouldn't really see it threaded through or integrated into the environment chapters. Now you do.
Yeah, that's the kind of thing I was alluding to.
Now you do. And it's not just threaded through the, and I think this is a recognition of the growing importance, although mana whenua would say those interests and values have always been important, but a growing recognition, including by the courts, of those different cultural values and interests that sit exclusively as a type of effect, but are also threaded through all the other kinds of effects. So there's cultural effects and ecological effects, there's cultural effects and landscape effects, and then there's just cultural effects. So my view is that this plan does justice to that issue in this part of the country. And certainly from imagine from Manawa's perspective, the submission points have not sought to challenge or oppose that approach, and by that I think you can take that it's largely supported, and within their own, I guess, non-regulatory ways, they have established and have working relationships with mana whenua in every part of the country where they do their business. And not least in Tauranga Moana, where Manawa has its origins in the Tauranga Electric Power Board, 1924, with Ngāti Hangaro, which is where their first scheme, which is the Kaimai scheme, was established. It did collapse on opening, a few days after opening, and could have taken out Muldoon, I think, but I just got shushed.
I would definitely support those comments that Ms. Burkhart's just made. It is definitely something that we see more and more in terms of Taonga Māori values being woven through plans. That's exactly right. I do remember when I first started in my planning career, there was the chapter, that was it. And I do remember processes around the country where we were in those mediation proceedings and hearing proceedings, and we were hearing that from mana whenua. We no longer want a chapter. We want our concepts, adopted and spread throughout and increase that understanding. So I think it has been a journey that, the whole profession and industries and organisations have been on as our understanding has increased, and it's no longer something that is maybe feared. Maybe, our understanding is there. And so then when we see wording and concepts, it's no longer something that we're, frightened about. We can understand where it's coming from and where the aspirations are and what might be being trying to achieve. So, we try and work with that as much as we can. We've been really focused and mindful over the last few years of strengthening our relationships with mana whenua. Historically, it was quite a transactional relationship when we were going through a consenting process, but now we realise that it's not good enough anymore, and those relationships need to be enduring for us. Yeah.
In the context of the Chapter 10 issue that we're dealing with here, eco and Indigenous biodiversity, yesterday there was 3 particular species that were highlighted by Ngaitai, Arohe, Kanuka and Manuka, just as examples of the sort of things that we're sort of discussing here. And it's against that backdrop, I suppose, that I look at these issues often and say, okay, so we've identified 3 species. We may not have identified them quite so readily previously, 10 years ago, 15 years ago. But now that they are becoming a more accepted and natural way of discussing or dealing with these issues, that they are real. And that's why it led me to sort of raise this issue, because they would, I assume, be some of the sorts of things that you, Manawa, would need to be aware of. I mean, you're dealing with particular species out there. Are they, and that's when I come back to Taoka or Taonga, are they Taonga in a Māori sense? Are they Taonga in a national or a regional sense and all that sort of stuff? Yeah. So I'm not sure I'm actually asking a question. I'm just sort of reiterating what came out yesterday as an example of the sort of thing that I'm referring to. I might come back later when Dr. Keesing is giving us some evidence. Thanks. That's all.
If I can just add to that, and probably when may not be this panel because they're the freshwater parts of the plan, but certainly when we get to the freshwater parts of the plan, Te Mana o Te Wai as the primary principle now under the NPS, is important to recall. Probably the one area, and I did pick up on the discussion yesterday around importing essentially a Tauranga Māori based effects assessment into some of these provisions, and just noting Dr. Keesing's experience that there may not be the practitioners out there that are able to apply that knowledge system to an effects assessment. Notwithstanding what my tahu might have said, and my apologies, I wasn't here to hear it. But I do think that's potentially an area where some care needs to be taken. No, not necessarily raising an issue with the requirement to take Tauranga Māori based assessments or perspectives into account, but certainly caution in relation to how the outcomes of those might be applied. And certainly there would have to be a proper basis for the outcomes of those kinds of assessments to form cultural bottom lines that might attract an absolute avoid, particularly as that area develops. And it certainly seems to be a developing area within which there needs to be more practitioners. It's certainly something I think we're a little bit more ahead of in Tauranga Moana, certainly in the marine ecology space. There are well-known Māori science-based entities like Manaaki Te Awanui, who have been doing these sorts of things for a very long time. Interestingly, in Tauranga, the partnership with the Waikato University is very strong, and you've got a lot of PhD students choosing to do a lot of work in the Mātauranga space. Not sure what the situation in Otago is, but certainly Dr. Keesing's experience is that it's yet to sort of come into the the everyday practitioner world that he operates in. And so requiring those assessments is one thing. Developing the resources to be able to do them properly is another. And then taking that into account when looking at, well, what's the response to the outcomes of that kind of process. Well, I hope that was helpful.
Thank you. Thank you.
Just a couple of matters. Paragraph 18, you make this statement that the MPSFM was only recently amended to provide even greater flexibility after significant implications of the approach became apparent. What changes are you meaning in particular?
So it's sort of, I can't quite recall the dates, but the most recent one that just came out seemed to address a few things that the prior one, the sort of immediately prior one, didn't, and introduce some flexibility around the functional need, around wetland management, and there's a specific carve out for Tauranga City, and mineral. I'm quite sure there was something in there for minerals, because the immediately prior version sort of established a very high threshold for which there wasn't flexibility. And so the one that came immediately after that, I'm sure, included at least those three examples of where some flexibility had been introduced. Right. No doubt someone had reflected on what this might mean and wanted to address it through some amendments.
Yeah, look, thank you for that. And that's a helpful reminder, and you're right, quite right about those aggregate and mineral insertions that went in. The reason that it pricked my interest really was that we were really discussing yesterday the fact that quite the opposite happened in relation to the final gazetting of this NPS, and that prior to the final gazetting, it was in a form that in Mr. Mark Christensen's evidence, offsetting evidence, he was constantly referring to it and saying it was different than the draft NPS for Indigenous biodiversity, because it did not require absolute compliance with the appendices. And when the gazetting occurred, that got changed and compliance was required. Now, he suggested that slipped in right at the last moment. So that appears on its face, at least, to make this stricter than certainly was in the draft form, which is why I was intrigued that you were talking about it as being more flexible, when yesterday we were discussing it being changed at the last moment to be in fact tougher on the Indigenous biodiversity side. Had you picked up on that change that occurred?
No, so I'm talking about the changes that occurred for the freshwater NPS.
Yes.
Yeah, okay. So Mr. Christensen's referring to changes.
No. What has occurred in the gazetted form
Yes.
of the NPS-FM between October last year and February, when it was gazetted, what occurred was that a wording change was made to require that the offsetting or compensation approach had to comply with the appendices, or the principles 1 to 6 in the appendices, and then but have regard to the principles, the other principles.
Well, that does move in the other direction. And my apologies, I hadn't picked that particular change up.
Well, it caused a problem for the way Oceania put their case. And Mr. Stevenson Christensen's response to my raising that with him was to say, well, yes, whilst it had required compliance with the principles 1 to 6, that they were outcome principles and they were not effects or fact, if you like, factual effects. So that he was obviously trying to argue with us that should be some wriggle room. But in essence, what he had referred to in the proposed regional policy statement, outcome of the effects management hierarchy and the 2 appendices, was that they formed what he called, I think that was his phrase, prescriptive limits. And I was suggesting to him, well, the outcome when that final change occurred in the NPS FM was exactly the same, that you had prescriptive limits that were imposed. Now, if in fact that was the conclusion we were to reach as a matter of law, he was then arguing that the provisions of section 104(1)(ab) did not allow that situation to occur. In other words, he was suggesting that if you reached the conclusion that these changes meant that there were prescriptive limits in the NPS FM, that he was arguing that that was a lesser document that was trying to, in essence, challenge the statutory provision of 104(1)(ab). So do you have a view on that?
I probably shared my view on that. I can understand its face why he might be saying that, but I don't. We cannot recognise that it's permissible for the plan as directed through national direction to put prescriptive limits on offsetting and compensation. So my view hasn't really changed.
Right. I mean, the policy C2 in the NPS on electricity generation requires that decision makers shall have regard, and it's mandatory, shall have regard to offsetting measures or environmental compensation, including measures of compensation which benefit the local environment and community affected. So it is a mandatory requirement that you shall have regard. Yeah. And Mr. Christensen's argument is that in effect section 104(1)(ab) requires that same thing, shall have regard. But the issue, I suppose, is does that prevent there being, as you mentioned to us orally, avoid policies? Does it necessarily prevent prescriptive limits? What's your view?
Well, if it does, there's a lot of corrections that need to be made to plans up and down the country.
Which have avoid approaches.
Which don't even allow you to entertain, mitigate, remedy, or the offsetting or compensation. Particularly in New Zealand Coastal Policy Statement would be an example. You see those avoid policies carried through for Section 6 matters into ONFLs, ONCs, where there will be, and I'm thinking, particularly I'm thinking of the Bay of Plenty Regional Coastal Environment Plan, and there are very limited exceptions to get through that avoid framework. They happen to exist for infrastructure in that particular context, but the submissions that were made by Mr. Christensen, and it sounded like I missed something by not attending yesterday afternoon, would have far-reaching implications.
Well, I'm
Work
intrigued.
against it being the correct interpretation.
I'm intrigued in that case by your the third and fourth lines of your paragraph 27, because where you're referring to the methods, you say, while these methods do not, quote, make the decision, close quote, on consent applications, and then you say, which is it that they cannot, as a matter of law, do. The method of implementing them is clear, direction and regional district plans to decline and or prohibited activity status. Now, why do you say that the methods cannot, as a matter of law?
I think what I've tried, I've probably, my reasoning's probably not as clear as it could be, because I'm trying to respond to reasoning that I also don't find that clear, because the decision maker will make the decision, the method can't itself. So it might be me not fully understanding or appreciating what the officer's saying when she says what she says.
I'll leave you lost it there.
I think I'm going to have a look at it.
What I'm really saying,
So-
here
so
is,
the
what
offer-
I'm really
yeah.
proposing to you is, why do you say that phrase, which they cannot, as a matter of law, do? What are you relying on in making that assertion? Now, if you want to take some time to think about it, it's important. And so let's leave it for you to be able to have some time to think about it whilst we're dealing with the other witnesses, and then I'll come back to you at the end.
Okay.
Because I do want to
Deal.
respond to it. All right. Okay. All right. So given that, that's my last
Thank you.
question to you. And how do you want to deal with the witnesses now?
I think Ms. Stiles. Oh, well, no, actually, Mr. Keesing, I think, should address his evidence.
Right.
And,
Thank you, Dr. Gill.
Thank you. Yes, so as work out, as pointed out, we error in my evidence, yay. In my appendix, where I'm addressing amendments to APP4, which is like page 40 of my Manawa appendix, under APP4 criteria for biodiversity compensation, there is a list of things under 1, A, B, C, D, and E, and I had recommended removal of D. I also recommend, and I just didn't put the red and cross through it, removal of E, loss, including through cumulative loss of irreplaceable or vulnerable Indigenous biodiversity. That should, in my opinion, also be removed from the structure around compensation.
All right, can I just ask you to just pause for a moment?
Yes.
While I find that brief.
Mm. So I had removed that from,
Sorry, you need to go back. Sorry, no, I've got it.
okay, yes. So in my appendix VK.3 at page 40,
Yep.
Under the proposed amendments to APP4, APP4 1E should be removed in the same way that it is for APP3. The loss, including cumulative loss, irreplaceable or vulnerable Indigenous biodiversity, should not be a restriction under compensation.
Right.
And I say that, even though those words are very similar to the thing we've just looked at in the appendices of the freshwater management plan, which has those very similar words there as a restriction to offset. The first thing is, what is vulnerable? And at its extreme, all Indigenous species in New Zealand are currently vulnerable, apparently. So it becomes a real nightmare from the ecology point of view to fix what that is trying to do. It is trying to limit you offsetting something that is vulnerable. Well, at the extreme edge, everything is vulnerable. There is no definition. And just because it's vulnerable shouldn't mean that you can't address it to make it better under a management plan or an offset. And secondly, just talking about irreplaceable, again, completely undefined. And from an ecology point of view, on the one hand, everything's replaceable, either its function or it is as a species. And the only examples I can think of where you go to remove a habitat, say, and the thing that stops you because it's irreplaceable is the presence of a highly mobile fauna, say a falcon. You can't replace a falcon. You can cause more to be bred, perhaps, and you might increase a nest by removing predators from that nest. And so instead of getting one chick, you get 3 chicks that year. Have you then replaced that in the place that you're trying to offset by creating another bird over here? But if it doesn't fly to your offset, have you replaced there where it was in the habitat you lost? It becomes a nightmare. But it's also not very important. The other rules, the other principles, and I agree with Mr. Houston that these should be principles, not limitations. These should be set out to how you should go about your offsetting to get the gain that you need to. There are other ways of making sure that all of these things here are addressed through the offset, through a proper offset plan. So that's my rationale around why vulnerability isn't particularly useful, important, and irreplaceability rules likewise undefined and not useful, and may have unforeseen negative consequences. That's the changes.
Thank you.
I am very interested in having a discussion with Mr. Kirikiri about the aspects we just talked about before.
Well, there may be other commissioners who want to ask other questions. So, yeah.
No, I think I pretty much got through all mine yesterday. Thank you.
Yeah, it was probably the only thing was around the principles rather than criteria you had to meet, and that change in the freshwater management NPS. And I think that does require compliance with principle 1 to 7 in both those appendices. Did you have a comment around those and how that impacts on the flexibility, if you like, that you're promoting in these things?
Yeah, well, the freshwater management plan under 2, A, B, and C are very similar to these, and they are limitations on getting an offset, and you have to comply with them there, which means the same thing as it does here. It stops an offset. That's my layperson's way of looking at it. So as an ecologist, when I roll along through here and I'm going to do an offset, I've done my avoidance what I can, and I've remedied what I can, and I've undertaken mitigation what I can to reduce the effects, and I've got a residual adverse effect, and I'm going to approach that with an offset, and it might be a small thing. And I come through here and I have to look at these things A, B, and D and stop my process if I'm picking one of those things, or argue my way around it. 9 times out of 10, I'm going to try and argue my way around it, of course, because I want the offset to occur, because there's going to be a good thing coming out of it. I think it's the same thing here. I'd be faced in doing the same thing under this regional plan by looking at stoppers to offset as it is there. I don't know the legalese of it all, but it affects me in the same way.
But this is, yeah, we're stuck with this.
Yeah, and I just have to argue my way around it. And if you talk to Dr. Lloyd, he'd say the same thing.
Yeah.
Present my evidence, but it's easy for me. I can present evidence. I don't make a decision, and I don't have to follow policies. And I can go, here's my ecological thought.
Yeah. Okay. Thank you.
Sorry, but I suspect your discussion might be a bit longer than the very short thing I wanted to raise. So I'll go first if I can. I just have one issue, and it's really just to get, I can't remember what your view was on the rarity criterion as to whether it should be a regional or national or ecological district approach?
I think it needs to be regional and ecological district. I think it needs to have both, but not national.
Okay.
Most important thing is regional.
Thank you.
They should have a lot more questions, but I guess the issue really for me boils down to how technical issues like this are interpreted, to a layperson. And the reverse applies as well, how Māori concepts are interpreted by other people or to other people. Because you made the point yesterday about they're not being, ecologists aren't trained in this sort of thing, and it's that issue around it is essentially interpretation. I mean, ecologists say something and somebody else is listening. Do they actually understand? Do they hear what the ecologist is saying? The same thing has been said about Māori for a long time. People have never understood Māori or what Mātauranga Māori is. So,
well, exactly. I had a fascinating discussion in a hui on Friday about Māori. And it took an hour for me to get to understand really where this particular hapu were coming from, because their interpretation of Māori was that you don't, this was in a wastewater treatment system. So the water had passed through wastewater treatment. It was being treated. It was coming out very clean. From my point of view, it was clean. I would drink it. Yeah? But the Māori hadn't been improved through that system as far as they were concerned. It had still lost its component of whatever that change had occurred to the Māori. And that was fascinating to me. But it took us a long time to work out what this was. So when the water that came out of this final treatment plant through new wetlands that we were proposing, et cetera, went into the stream, that was still a no, which was, like, what? What? It's clean, it's perfect. No, but the point was that the Māori hadn't been improved, you see? So that complication is the same as we get here. And when we're talking about Pteridium esculentum, or bracken, and if this plan says, and I take your point before about taonga being everything, which it could be, then if taonga is a fluctuating thing, and it is, because sometimes the what you value in these things changes through time, and the amount of those things and their usefulness change through time, if that's a floating concept across the rohi, which it will be, then how does this plan react to the fact that everything may have a use rate value or a taonga from time to time, if you've also got an avoid policy following in there? Because if you've got a hillside of bracken and that's valuable, and you have an avoid policy, and through Mātauranga Māori you end up with that assessment, which you should do, how do you manage that then?
that's a challenge though, isn't it?
Yeah.
It really is. I mean, I go back to Ms. Freund's comment early on about we've come a long way in the last 10 years, let alone 20 years. We have come a long way, but there's still a long way to go. We've come that far, but there's still that much.
I think the minute you put an avoid policy in, you shut down the discussion that we need to have through a consenting process or through whatever process that might be. Now, in the absence of an avoid policy, you have to make sure that good discussion and outcomes can occur, because you don't want that not to occur, because you are playing with values. But the avoid policy shuts all that down and stops you probably getting to better outcomes. That's my main worry ecologically here.
Because if you had this conversation in a marae somewhere, most marae around the country, most people wouldn't understand it. They would just be blue to the ordinary person on the marae. Because I get all the questions afterwards. We have the conversation, then they corner me. They say, now, what are those guys talking about? And so that sort of signifies that we haven't, we've come a fair way, but there is still a long way to go. And the trick is, what language? What is the language you use I'm not suggesting for one moment that you've got the answer, but I know when you point about the more you discuss it, the more you give an opportunity, people opportunities to say what they don't understand or make them not feel like dummies and all that sort of stuff, you know. The better I think the conversation becomes. I mean, 10 years ago, 20 years ago, I wouldn't be in this conversation. Partly because I'd feel embarrassed about putting my foot in it, you know. But more and more people aren't embarrassed about doing that now. They're quite open. They'll come out and say, boom, and we need to know. Yeah. Sorry, we could carry on all day, and I think that's probably enough, but if you accept the point and you're quite cognizant of the fact that this level of understanding it's still yet got the balancing isn't quite
needs to grow.
there. It still goes like that. Yeah. Thanks very much.
Just before, we're going to have a break for two reasons. A, so that we can styles will run, but also so that you have some time to think, Ms. Vicker. But just before we do break, I just thought I'd recount that as you told that tale of the difficulty for Māori in coping with the concept of loss of Māori and water being treated. I had a not dissimilar situation years ago, sitting as a commissioner in the Marlborough Sounds, where a wastewater stream from a salmon hatchery was proposed to go out into a heavily sediment loaded area in the seawater. And so what it was going to do was produce a small plume that was going to be beautifully clear water, as you say. But the objectors found that an absolute affront to the concept of swimming through heavily sediment loaded
Into clear water.
into beautifully clear water, back into the sediment loaded water. Almost the same sort of concept.
Yeah.
Anyway, that's just, we'll break the quarter now. Thank you.
So can I get my question out of the way? Because I don't want to finish on it because it'll be quite a dud finish. So I think, and I tried to articulate it before. I think what I've done is tried to respond to what the officer has said. So the officer's response to not accepting to delete that decline correction in the method was because the method doesn't make the decision. And I think my response is probably a little bit too tongue-in-cheek, because it's really a basic proposition that a method doesn't make a decision on an application. A consent authority does. So it's probably a point I should have just left, but I didn't. And I hadn't intended to get into a discussion around, the hierarchy of objectives, policies, methods, what gives effect to what can, it was really just to respond to a suggestion by the reporting officer that a method doesn't make a decision. I agree a method doesn't make a decision. Only a consent authority can make that decision. So I'll leave it there.
No, that's good. Thank you. Stops.
Maureen, I don't want to say too much. I just want to touch on a couple of points, particularly a couple of things that were traversed yesterday by yourselves and a couple of the witnesses, particularly Ms. Hunter for Contact and Oceania. Obviously, my planning focus is on how these eco rules affect renewables and the ability of this chapter to work with the National Policy Statement for Renewables, as well as all the other RMA direction and other NPSs. And noting, of course, that there is no currently national direction on biodiversity. But I also note that the commentary that I've sort of raised on behalf of Manawa is not dissimilar to the issues that would relate to other nationally and regionally significant infrastructure. They're the same kind of issues and blockages for those types of activities that have that national direction. One of the points I just wanted to pick up on was around the whole offsetting and compensation issue. And as you've heard a number of times, the combination of the policy, which takes you through the effects management hierarchy and ends back at a void, together with those appendices which don't allow you to do offsetting and compensation in some situations, as we've heard from Dr. Keesing, which lead you round in some circles to end up at a pretty stuck place, in contrast to the National Policy Statement on Renewables, which at C2 envisages using the concepts of offsetting and compensation for considering renewable electricity generation activities. And I, as following the discussion that you had yesterday, went back and had another look at the wording of that policy C2, and it makes reference to decision makers having particular regard. It doesn't say that that's at the time of consents. It doesn't refer to consents in that policy. And so I guess I had always read that on the basis that it was decision makers at any point enabling that consideration to occur. And therefore that this RPS essentially blocks the ability to use those tools in some situations for renewable electricity and other significant infrastructure projects. That doesn't seem to me to give effect. It sort of rules something out too soon. And I guess I pick up on the way that Dr. Keesing describes it as having a discussion, and what I guess I talked to yourselves about some weeks ago with the energy, which is about a policy statement enabling pathways for assessment and not ruling things out too early. And I guess from my reading, offsetting and compensation are tools to deal with effects of activities. They're not a means in their own individually, they're part of packages, and they can be a method of actually achieving better outcomes that you don't necessarily get through your avoid, remedy, mitigate situations. And particularly when you get into things like compensation, where you, in my experience, you're more likely to end up with net gain to justify a compensation pathway for dealing with what you can't avoid, remedy, and mitigate. So, and I guess it also turns to the conversation that we had earlier this morning with Commissioner Cubitt, talking about the difference between significant natural areas and all other biodiversity under that maintain direction from the responsibilities. Maintaining, in my planning perspective, not legal perspective, is about looking at things more holistically. It can't simply be protect all Indigenous biodiversity. That would potentially lead to ludicrous outcomes like cabbage trees in residential gardens. They're Indigenous biodiversity. If you have to protect them, it's stretching things too far. And I guess I see things like compensation as a method that you could have maintenance of biodiversity values as a whole, lose some, gain a lot, and the focus on no net loss can be taken quite negatively some days. If you flip it around and take it to net gain, you're looking at activities as a conduit for doing better. And if this kind of focus on avoiding just ties you up in almost that negative response of, if you can't avoid, just stop. And I'm well aware of Dr. Keesing's example yesterday of the can't avoid, so we won't give example. And I know a number of clients who have those perspectives. And it seems to me a really wasted opportunity for biodiversity values to just stop. So I think that's something that really needs to be really worked through quite carefully, and to not rule out pathways and opportunities. The other thing that I just wanted to reflect on is what in all the conversations in papers seems to really just highlight a lot of confusion around these policies 3, 4, 5, and 6, where you've got some dealing with existing activities and some with new, you've got some dealing with significant areas and some with all areas. You've got a couple of different policies that have different wording around effects management hierarchies, but it's not really clear if they actually apply in 2 different hierarchies or essentially the same one with different words. And a little smoothing of the policy approach might go a long way to providing clarity, which would help interpretation later on down the track for lower order documents. And particularly deal with duplication. So when you're dealing with something like renewable electricity, new activities under policy 4, you would have to then still apply the effects management hierarchy under policy 6, because at the moment it looks like you do. Or maybe you don't. It's not entirely clear to me. But that seems to undermine it somewhat, if you do. Sorry, did that help?
No, thank you for that. And just a couple of, I did have a couple of questions in here on your evidence. Paragraph 10.5, you're referring to the provisions for specified infrastructure included in clause 3.11 of the exposure draft of the MPSIB. And I take it, from that you're looking to echo P5 there to make sure that there's a reflection there. But I just I was interested there that I suppose in the MPSIB exposure draft, it's still referring through to an effects management hierarchy, which still has a void as the final step, I suppose. And I just wondered, a lot of the, if we do have the NPSIB exposure draft gazetted as drafted, where's that going to leave you, I suppose? Because some of what we're hearing here is
essential
there's things
tension.
drafted there anyway.
And that essential tension that we've got between a number of national policy statements, isn't it? Where they're talking about different issues or topics in parallel and not coming together and dealing with the conflicts between them necessarily. I think in looking at this evidence, which feels like a really long time ago now that I wrote that, we were very focused on what the exposure draft was saying. And
You're probably anticipating that it would have been out by now.
well, exactly. And we might have
Yeah.
some answers, even if they're not helpful answers, because they may, if it continued the way it was, have led to this conflict between policy statements. In the absence of that, and as time goes on, I guess I become less fixated on what that was saying at the time and sort of step back and think, well, there was a lot of reaction to it. It hasn't happened. We don't have that to rely on for any of us to make decisions for us or help us make decisions or recommendations. And I guess the key thing here is that we need to still figure out how do you work your way through something that allows opportunities to consider proposals in time under different frameworks that are asking for different things.
Yeah, where there is a bottom line of a void if things don't stack up to the extent that they need to, I suppose.
And at the end of the day, I guess that's also in the way you word things, because we don't want to have a regional policy statement that says anyone can do anything if you just argue hard enough. There's got to be a bottom line. You've got to be able to avoid significant adverse effects or significant values. But it's about not precluding that at a blanket level that doesn't allow you to the lower order plans and ultimately consent processes for projects, which is where it really matters, to explore whether you can create, for example, a renewable energy and renewable electricity generation project, which we've explored the significant benefits and need of, in a way that's appropriate in whatever environment and whatever effects it has, and hopefully has some pretty good environmental outcomes as well built into it.
Yeah, well, thank you for that. Just paragraph 10.7, not too far along. You talk near the end of that paragraph, I think you're referring there to an effects mitigation hierarchy, which I presume that should be effects management hierarchy.
Yeah.
But near the end, you talk about in some instances this will be by applying an effects management hierarchy, and others it's likely to be too simplistic an approach. Applying the hierarchy may not allow other force directions to be met. I was just wondering if you could give us sort of an example or expand on that a little bit. Sorry,
Trying to turn my mind back to what I was
No,
sorry.
sorry.
I wrote it. So I guess what I was trying to do here was to reflect on the method. So you've got a policy or a set of policies that look at effects and an effects management hierarchy approach of considering things in a systematic way. And then a method that takes that a step further, and it says if you don't follow that systematic process, regardless of the outcomes, you're directed to decline, or the decision maker is directed to decline a consent, which sort of feels like it's stepping quite a few processes in between. It's also not looking at the rest of an application, because applications don't exist in one dimension. They're not all about ecology or any one effect. They're a holistic thing, whereas this is asking for an effects management hierarchy systemized approach for the ecology basis, in fact, aspect. And it's just, it feels like it's starting to get a little bit too far too soon for one topic out of sync with everything else. And that's where I guess I was thinking it's very simplistic when you just look at one topic to think about it in one way, but projects aren't one-dimensional.
Yeah.
There's a whole lot more to it.
So
And
what you're seeing through an AE, for example, all the information could be in there with everything else around the effects management hierarchy, and it's something that decision maker is going to have to turn their mind to in making the decision, but it's not necessarily something that should be
tick,
tick in a really prescriptive way through the
yeah.
AE document, for example.
And often with AEAs and applications and the complexity of them, you're telling a story and explaining what isn't reasonable, available. And so you might have a situation where ecologically you might be able to hypothetically avoid or remedy an effect on an ecological basis, but there might be a functional need or a landscape need or another need that outweighs your ability to do what might be if you're just looking at ecological, and things don't work in linear ways.
Yeah.
And so your AEE is about looking at how things work together and working through how you get the best outcomes on the ground for a project. And sometimes they'll limit a project internally. You might have conditions that are volunteered on an application that limit some aspects of what could otherwise be provided to deal with effects. But they might also limit how you deal with other effects.
Yeah, I've certainly been involved in a lot of examples where it is a trade-off between different effects to try and overall get on balance the best environmental outcome.
Whereas this almost feels like it's just saying, well, you tick cross on ecology and that's it, without looking at that holistic.
Is there any reason under those methods, so just looking at them again, that that might just be, in your policy analysis in your AE, just to go tick through that, which would in theory satisfy that M4 anyway, wouldn't it?
And that may be the answer, but I guess the other thing is remembering that the M4 and M5 also then say if you haven't followed that, just go straight to decline.
Yeah.
Which
I wouldn't want to see a prohibited activity in a plan on that basis.
No, it doesn't feel like the right outcome, does it?
Okay, no, that's helpful just to understand that a little bit more fully. I'll just check. That's all I had in there for you. Thank you.
Yeah, thank you. All the scribbles on your evidence is also on paragraph 10.7. I actually had a question there. You're saying we should delete it altogether. So I note in the exposure draft, put it in my hand, those principles are again at odds with some of the evidence we'll be hearing, that they have to be complied with, and you've got a irreplaceable vulnerability in there. So sort of back to that.
Are you talking about the freshwater principles?
No, this is
or the IB?
IB,
Yeah.
which is applying the same approach, that they're not so much principles as criteria to apply.
And again, it's that difference, I guess, between criteria and principles and guidelines. I mean, certainly the one and the appendices under the freshwater NPS are principles. They're not criteria.
Yeah. Because I think in your table at the back of your evidence, you're suggesting we should actually adopt this approach, but maybe not on reflection.
On reflection, I think we were all very caught up in what we were responding to in a very quick period of time, without knowing where that might lead to. And I find it hard to conceive that if the NPS IB is gazetted, that it will be the same as what the exposure draft was. And so I have some hesitation in simply going with what that was in the absence of what it may or may not become.
Has someone told the authors of that to be listening to this? So
we,
is
can
that not
only,
useful?
we can only hope.
Ms. Hunter provided a draft section. Have you had a chance to look at that and any comments on? Because one thing she has recommended is that P6 is the fixed management is taken out of that. Because I think you've talked about that being a method rather than a policy.
And I have looked at it, and we did talk as we talked with both Ms. Hunter and Meridian's planning witness, and we did the work for you guys in terms of trying to put together that energy related response. We talked about trying to do the same with this. Part of the limitations on that was time, partly was in terms of, you know, the scope. We tried to be quite sort of focused on this one, this chapter, rather than holistic. And I guess if I was to have the opportunity to take a step back, I would probably look at policies 3, 4, 5, and 6 together and simply say, what are they trying to do? They're trying to enable some existing activities. And the question earlier was, do you even need to do that if you've got an existing use regime under the Act? They're then trying to provide special pathways for some activities and then trying to take a really, really directive stance on everything else. And at the moment, it doesn't read in that sort of clarity of thinking. It's very circular. So if I was to have the opportunity to look at that, I would want to look at it holistically rather than just picking and tinkering.
I think one of the suggestions Ms. Hunter's made is, which I guess has been made in every section of this piece, is to bring in that social and economic well-being factor into the objectives. And I note actually in the exposure draft, there are, I didn't pick that up with you yesterday, but it does reflect what's in the exposure draft around, we recognise we've got to protect the stuff, but it's got to be in such a way as we can actually carry on living pretty much.
Yeah.
And there are a number of objectives and policies and clauses in there that address that. So again, you may not have seen that, but did you have any comment around one, whether that's necessary in this section when we have to, were you involved in the new issue?
Yes, yes, I was involved in that call.
So we've got that promoted and various other changes promoted in the IM section. Is that necessary in this section? And if so, the form of it, were you?
I haven't turned my mind to that level of detail. My initial reaction is that the whole purpose of your significant resource management issues and your integrated management chapter is to bring those things, all those things together, and that each stream should be dealing with its own thing, but always remembering that it has to be dealt with as a whole. I mean, my take on why those things are in that exposure draft is because of what they were trying to make it quite clear that it's not ecology is not an island. It's not all things in itself, and that, as you say, protecting Indigenous biodiversity in all things in all ways has to have those other elements considered. Whether you need at the RPS level to weave that into every topic or rely on those higher order integrating sections is probably a decision-making question, because if you're going to do it in one topic, do you want to then do that in every other topic?
It's been what we've been faced with, I guess, from this. I was hoping you would make it easy for us.
Sorry.
No, thank you for that.
No, I didn't have any questions.
When I listened to you talking about the provisions of the NPS RG, I was just thinking to myself, that was 2011, and we get a national policy statement on freshwater management, addressing offsetting in a very restricted way in 2023. Really, a concern would be that there's an attempt to persuade us to take a totally different approach to that prescriptive limit, when in a national sense, at a national standard, or a national policy rather, statement level, some 12 years after the NPSG is aims C2. That's exactly what's happened. They imposed prescriptive limits. And you, in essence, you're saying that that's just bad planning.
I think it's a function of different things being considered individually rather than holistically. And we've touched on this before, of the question of why has the NPS REG never been amended, revised, replaced, updated? A question that we don't have the answers to. I think you've got a general presumption with the NPS REG that says these things are really important. What we've got now is important to keep and protect in terms of its capacity. We need a whole lot more. That importance hasn't changed, and in fact has increased in importance as time has gone on, and has been further recognised through things like the national direction around climate change responses. And the generic direction of when you're considering renewable electricity generation projects of whatever kind, that you look at them in their entirety and you look at avoiding, remedy, mitigating, offsetting and compensating. Actually in 2011 was quite forward thinking, because offsetting and compensation weren't that heavily used back in 2011 and have evolved a lot since. The way it's been interpreted and applied through the National Policy Statement on fresh water is looking at freshwater and aquatic offsetting and compensation, and is looking at principles for when those should and shouldn't be used. You've got to comply with those principles, but some of the detail in those is things like examples for when it's not appropriate include It doesn't, they're not criteria, and that's the difference to the RPS. It's taken examples and principles and turned them into black and white. And so again, it's that taking something a step further than it was intended. It was aquatic offsetting in a freshwater management only realm in terms of principles, and are saying in all ecology, here's your criteria. And so it's conflating.
Yeah, and against the background too, where nationally the aquatic ecosystems were under degraded conditions, particularly on lower levels of the catchments, and were desperate for needing protection.
And then conflating that to all ecology and all systems. So
which makes you wonder whether that's a potential driver for the delay in the gazetting of the NPS idea. Who knows? I know
those kind of issues were raised in the feedback and submissions that were made on the exposure draft.
And the other difference too is that in the last few years, we've had the national direction in a statutory sense of the net carbon zero target, and was from people like and other generators have been coming along saying that we've got a massive task, we've got to get cracking on. There are going to be effects on Indigenous biodiversity, and how do we do that in a way that actually hopefully enables the net gain, and which I see, by the way, that in the NPSFM they term that additionality, which is I assume the same as net gain.
Another word to get used to.
I can't even say that.
Yeah, no, your evidence has been helpful, but I just leave it at that. I'm probably talking rather than asking questions, which is I'm always critical of other people doing. I better stop. And I don't think I had any other questions for you when I looked through the evidence on this chapter. So thank you.
Thank you.
Ms. Foran is there, and there was one question I wanted to raise, but there may be other members of the panel wanted to raise some questions. No?
Not Ms. Foran, but Mr. Keating, just in relation to something you just raised.
Right. Well, deal with that.
Might actually be more for the land and fresh water section, but there was a comment about, and it goes back to the issue around biodiversity, decline in Otago, one of the large areas being irrigation up Central Otago, around Waikato and that. And there's been a criticism of some of the reasons that people are suggesting that's happened is because of conservation, freeholding the partial release stuff. So the high country has been no longer grazed. Its farmers have pushed down onto those areas, had to cultivate to maintain productivity. That's had the flow-on effect on biodiversity and fresh water.
It's had good and bad flow-ons.
So
It's had good and bad flow-ons.
yeah, so I was just wondering if that is actually how you see that it's happened in that area.
Yeah, I mean, whatever land use that we push things to has consequence. And one of the consequences of pushing dry stock farming off the tussock grasslands so that they might revert to tussock grasslands when they should be forest anyway. And maybe they would get there, but they're really dry now and over nutrified. But one of the problems of pushing people down, squeezing them into the space, is they have to up their intensity. Upping their intensity creates problems with pollution into the streams. Go those increased, normally often dairying, pivot irrigating increases. Those farmers also end up with a lot more pressure and debt on them, so they farm harder. And in farming harder, you can sometimes afford less protection on your outputs. It gets into the waterways, and the effect is generally accumulative downstream. So, you know, more and more farms input, and it gets worse and worse downstream. And the bottom of the system, catchment, suffers the most. And it is a consequence of pushing those farmers down off those hills.
So again, it's another example of the avoid approach and the impacts that it can have that have been thought through.
Here's a shock. You have to think of that ecology as a system. You can't just look at one bit, you know, and where you push something in one direction, there will be ramifications wider. So you need to look at it on the whole and say, well, what happens if you change that approach, or if you avoid that, what does that flow on to? One of the interesting things that we didn't talk about is if you promote corridors and you say, well, let's make sure that we've got this corridor through here. Corridors currently also increase stoat and ferret transportation between two lots. That can be absolutely adverse to the piece fragment that wasn't connected previously. And we have seen that in Australia happen quite a lot, whereas they used to say, well, let's plant up a corridor along a roadway to connect two bits of bush. Oh my God, we've lost all the biodiversity in that other bit that was secure because we've opened it up to predation. That does happen in New Zealand. So there are lots of things to think about. You can't just think of one thing.
Yeah. Okay, thank you.
It was for just all of the generators, including one that come along and emphasise the need to meet the net carbon zero target, and have canvassed various burdens that places nationally on the generators, and it's just struck me that hearing that evidence that there's going to be significant effects if you went down the solar pathway. Somebody can contact us, figure of over 60,000 hectares land would need to be occupied if you took that approach. They weren't suggesting that it was the only approach. There's then the landscape effects, etc., of wind turbines and the like. But none of that evidence canvassed at all the option that increasingly you see in the newspapers or in articles about the major tower type of structures, wind tower structures offshore. Is that something that Manawa has been keeping a tab on or is interested in or is looking at, and in particular that joint venture between the Danes and the super fund that offshore at Maui, whereas I understand it, the concept would be involving about 60 odd massive towers, about the size of each of them the size of the Sky Tower in Auckland, with a blade of about 120 metres, radius, diameter of 240 metres, and as I understand it, capable of generating at one location 10 to 12% of New Zealand's electricity needs. Is that the sort of thing that you are looking at or considering? And in an Otago setting, is that a possibility offshore here?
So Manawa are keeping a sort of a watching interest in that space. I don't believe that we're actively considering any offshore wind at this point. I think firstly what will need to happen is some legislative framework to enable offshore wind to be developed in New Zealand. I understand that the government are looking at that. Minister Woods has indicated that previously in speeches, but it's something that we're watching. And I think from what I've read in like the media, that's most likely in the Taranaki region at this point in time. I couldn't comment on whether there's sort of potential in the Otago region for offshore wind. It's beyond my sort of knowledge of that at this time. Yeah,
I could help you there because we're
okay.
doing work for 5 of those.
Your microphone.
If I might add a little something, because we're doing work for 5 of those companies who are preparing to look at how to consent those. None of them are looking here. They're all looking in the Bight, the Taranaki Bight, because the depth profile works there.
Right.
Primarily.
So is the depth profile too deep over here? Yeah. And what about onshore? Is it just not the consistency of wind to justify the cost of those sort of towers?
As in wave generation.
No, sorry. Onshore.
Of wind farms.
Yeah.
We've got 7 potentials rolling now. So yes, all the companies are scrambling to do as much as they can.
With those bigger towers?
No, they're too big.
Too big.
But they are upsizing. So a lot of the generators are upsizing to larger towers that exist right now, bigger than the V90s currently are, top of the range. But they're not as big as the offshore ones. But they still won't generate enough. Apparently.
Thank you. That's a question I have to raise. Thank you.
Thank you.
Speaker.
Yes,
The end of it.
that's the case for Manawa.
Thank you very
Kia
much.
ora.
Right. Got it. Okay.
They're just joining online.
Oh, sorry. Two commissions with different schedules. The technical one. Got it, Ms. Me. How are you?
Hello, can you hear?
Yes, we
Oh
can.
gosh, cool. I can see my giant face on the screen behind you, slightly off-putting. I'm just hopefully going to be really quick today and just touch on a few points from my evidence. So hopefully give you back some time in your schedule.
Thank you.
So Folden-Hogan's submission describes, and my evidence briefly covers the locational constraints of aggregate resources. Essentially, quarrying can only occur where aggregate resources are present, and that sometimes coincides with areas of Indigenous biodiversity. Aggregates are a high volume, low value commodity, and transportation costs make up a significant portion of the cost of aggregates. They play a critical role in the delivery of buildings, roads, and other infrastructure. My evidence proposed a pathway for quarrying activities within SNAs be included in Eco Policy 4. And I note that Ms Hardiman has reconsidered her original opposition to a pathway in light of the recent national direction. The primary difference between the wording proposed by Ms Hardiman and myself is that I had intentionally omitted the phrase that could not otherwise be provided elsewhere in New Zealand. The phrase comes from the MPS highly productive land, but I note that the more recent updates to the MPS freshwater management and NES freshwater do not include a clause about obtaining the material elsewhere in New Zealand in relation to quarrying. Viewed in isolation, this phrase is problematic in the case of quarrying activities, as aggregate resources potentially can be obtained from elsewhere in New Zealand. However, unless the quarried material is a specific product, unless it's something very specific, it's actually unlikely to be, that's likely to be cost prohibitive. So I generally support Ms Hardiman's inclusion of consenting pathway in Eco P4, but in my opinion, the pathway should be open to quarrying activities that provide significant national or regional benefit without that particular qualification. In terms of the effects management hierarchy, Policy 6 sets out the effects management hierarchy in relation to Indigenous biodiversity. In my evidence, I proposed amendments to align the effects management hierarchy as that set out in the exposure draft on the NPS Indigenous biodiversity. And I've been listening in this morning, there's been quite a bit of discussion around that and where the exposure draft may actually end up. But in my opinion, that the wording set out there, it does actually address the two issues I see with the policy. Firstly, that the first step would be to avoid adverse effects as a first priority, which could be interpreted as simply avoiding an activity outright. And secondly, the onerous requirement to offset residual adverse effects or avoid adverse effects with residual adverse effects, that can't be compensated for, even if these residual adverse effects are minor or less than minor. The wording taken from the exposure draft would go some way to addressing these issues. And that's a similar approach to what's in the effects management hierarchy in relation to natural inland wetlands and rivers. That the residual effects have to be more than minor in order to end the effects management hierarchy. And then in terms of the application of the effects management hierarchy, it's under Eco Policy 6, it's very broad in its application, and it seeks to avoid any residual adverse effects on Indigenous biodiversity, even if the residual effects are minor and regardless of the value. In my opinion, applying the effects management hierarchy as envisioned under Eco Policy 6 to all decision making where there may be an effect on Indigenous biodiversity may not be appropriate where the activity falls outside of significant natural area. It should be amended to enable its application where it's appropriate and not require its application where there may be any effects on Indigenous biodiversity. Thanks. Whipped through that pretty quick.
You did it, you did, and you're a little too fast on that last part for me. So what was that addressing again, if you would?
The last point was around where Eco Policy 6 applies, and that applying it to any, requiring the effects management hierarchy be utilised for any decision making around where there could be an effect on Indigenous biodiversity is too onerous. It should really be, it could be used, but requiring its use on all decision making, regardless of whether that is regardless of whether the effects are going to be any more than minor, and regardless of the value of the Indigenous biodiversity in question is too onerous. So that's Eco Policy 6, its application versus its application under Eco Policy 4 for new activities within significant natural areas.
Yeah, okay, thank you. Now there may be some questions from listeners.
Yeah, thanks for that summary. I do have a couple of questions here. In relation to your paragraph 13, and you're talking about quarrying may result in a reduction in physical extent of an SNA, albeit temporarily. And I think some of what you're saying here is that where the effects are temporary, there shouldn't really be a need to sort of head off down the effects management pathway. And I was wondering what you're referring to there. I mean, are you thinking that the area would be restored after the quarrying, or what are you referring there in terms of where you refer to temporarily?
So what I was touching on in that paragraph is that Folden Hogan's original submission was around proposing amendments to Eco Policy 3, and I'm just touching on the rationale for that. But then I think actually the better option is the pathway under Eco P4. But in terms of the temporarily nature of that's more about the reduction in the physical extent of an SNA, and a quarrying is a temporary activity, and in theory restoration could mean that the extent of the SNA could may only change temporarily, and it could go back to the original extent after the restoration of the quarry. But that's kind of a minor point, because I actually think the best approach is not to amend Eco P3, but rather a pathway under P4.
Right, okay. Yeah. And I think Mr. Ensor, when he spoken to us earlier, he talked about possible kind of, I suppose, restoration, regeneration, whatever you want to call it, post-quarrying activity as well. But although he was unable to give us any examples of where that's actually been undertaken successfully, are you aware of any examples where, say, I mean, and I suppose it's not only SNAs, but where a quarry has taken a chunk out of a reasonably significant area and then been rehabilitated in a successful way back to sort of, similar values?
That's a really fair question, and I actually knew Tim was asked that, so it would have been advantageous for me to have gone back to Folden Hogan. I'm not aware off the top of my head. What I do know is that the consents nowadays are far more stringent than they had been previously. So it's more that in the future we could expect that to be happening, rather than it has already happened in the past to that same level. It's probably, yeah, I can't give you a specific example of where that's actually already occurred.
Yeah, right. Thanks for that. Just looking through my questions here. Some of them are probably a little bit redundant now.
Yeah, there's been some good discussions this morning.
Yeah, I don't know if you were listening yesterday, but we had some good discussions yesterday too. I did some points around the MPSIB, but I think now Eco P6. One of the things I sort of found in your evidence a little bit, you're referring quite a lot to section 6C, and that often in some instances section 6C doesn't require a certain level of protection, and that you're stating that the provisions that we've got here are going beyond section 6C. I mean, I suppose section 6C is only matters of national importance, and we've also got, you know, section 30, and that, you know, what our considerations here are a little bit broader than just section 6C matters. I'm just wondering if you've got any comment around that and around the approach that you've taken in your evidence around section 6C.
Yeah, I do take your point, and I've heard some discussions around the differences this morning between those two sections of the Act. I guess I've tied it back to section 6C, but it doesn't necessarily need to be tied back in that to that space that avoiding activities is probably not a requirement under either of those sections. And that it's weighing up of activities and the whole activity rather than the ecological impacts, ecological effects in isolation.
Mm. Do you agree that there's a point where it is appropriate to avoid or have some bar? Or
I think I definitely think there's a difference between Eco P4, where it's within a significant natural area, versus Eco P6, where it's just anywhere, where there's a potential effect. And I think there's a much stronger argument for making your way down the effects management hierarchy within a significant natural area that's been identified because of its significance.
In paragraph 33 in the amendment that you're suggesting to Eco P6. And I don't know, have you seen Ms. Hunter's suggested amendments as well? I mean, she was suggesting taking the hierarchy itself and putting that in a definition and then referring back to various other things. But I just wondered, you're suggesting where appropriate is added into the introduction to Eco P6 there. I'm just wondering what your intention is with that. Are you thinking that then it would be up to the district plans to provide guidance on when it is appropriate? Because I would sort of imagine that otherwise it's left quite open for consent applicants, and it may not give them a lot of certainty as to what they have to deal with consent applications. It could sort of backfire a little bit.
Yeah, I think on one end it's required under all circumstances, but to include the where appropriate clauses to kind of give a bit of flexibility. And I guess there is a balance between flexibility and certainty here, but if the alternative is it always applies, I'd rather, I think that the approach of applying where appropriate, although yes, it takes away from the certainty, there is flexibility there.
I suppose I'm just seeing potential issues where the council dealing with consent applications, if that wasn't then defined through a district or regional plan, where there could just end up being more debates, discussion, argy-bargy through the consenting process, because the plan hasn't provided guidance that's certain in any way. But I do take the point that what you're trying to say here seems to be that it shouldn't need to happen where the effects are, possibly reasonably minor.
Yeah, and I've not read I didn't actually watch on Monday to see what ended up happening. This is just kind of one solution that I thought might address that issue, but so I'm not actually sure of the solution put forward by Ms. Hunter. It may be that it is a better option. I'm not sure.
Yeah, and I think we sort of had we'll probably get more over the next couple of days as well, different options coming forward around how to address this. No, I think that's all the questions I had. So thank you very much.
Yes, thank you. And Bianca has kindly asked questions that I had mainly identified in paragraph 13 and around P6. I just had a quick look at what Ms Hunter promoted in terms of P6. And I think all she's done there is taken out the fence hierarchy and put it into a definition. But you're promoting two steps here, basically, I think. One for SNAs and one for other Indigenous biodiversity, which is where appropriate comes in. And I guess the issue there is how we make that clear, I guess, in a policy sense. But I'll leave that. And the only other thing I wanted to ask you about was, when you raised the issue with the cost efficiency with quarrying, I don't quite understand the regional public benefit aspect of a quarry, because my understanding of quarries, if you're 20 or 30 k's away from the source, suddenly you become economically prohibitive. So quarries generally have a regional function, have a local function. So what does regional public benefit mean to you in a quarrying sense? Is it like a large central quarry that's going to provide for the whole region, or what does that actually mean?
That's a very good question. Because you're very correct that the cost of the quarried material doubles when you take it over 30 kilometres, and then it just keeps going up from there. So there's very little regional movement of aggregate. It is generally used pretty close to the source. So you do raise a very good point around the term regionally significant, and is that in fact an appropriate term to use? Yeah, I'd have to actually think about that more. I've kind of just up to this point accepted it as a given that's the wording that's used in all the pathways at national direction to date. So I'd need to actually think about that one a bit more.
Yeah, I guess the logical, well, to achieve some common sense, any local quarry has a regional benefit because it's not dragging aggregate across the region. So I don't know if that's in the thinking, or it just seems a strange way to deal with quarries.
Yeah, and you're right, there may be some rationale behind that I've not seen, but that's something I can have a look into.
Yeah, so where did that come out of? Which NPS?
I think most of the there's I think three pathways that I've been looking at: the NSF, the NPS FM, the NPS HPL. They all do mention the regional benefits. Yeah, so at the moment, I think it's actually across all the pathways for quarrying or aggregate extraction. Yes. Yeah, so maybe the regional benefit is as simple as you said, that it's not having to take material and the corresponding emissions between regions, or maybe there's more to it than that, and I can probably look into that and have a better response.
Yeah, I mean, in the section 32s and informative documents of those NPSs may help us there, so that would be quite useful. Okay, that's all I had. Thank you very much.
Kia ora, Christina.
Kia ora.
We go to para 23 in your evidence, where Fulton Hogan's method to replace the words kaitahu values with tauka values on the basis that kaitahu values are potentially broader. I'm not quite sure why that's a sufficient reason to change the words. Can you explain to me why?
That was in Fulton Hogan's submission and was less a matter of my evidence, but I guess it was relating to that this is within the eco chapter rather than one of the broader areas of the RPS, and that in the maybe that the TARCO values are more applicable to the eco chapter rather than the broader values. But to be fair, it's not particularly, yeah, I can see your point here. Yeah.
Yeah, I mean, it may appear to be picky, but I may need to redirect that question to Ms. Hardiman also later on, because it's not just because they're potentially broad is, in my view, not a sufficient reason to change it, because it's arguable that Tauka values are broader than Kaitahu values, and
I'm certainly no expert on Kaitaho values, but I imagine there could be other areas where they do relate to eco matters.
Yeah. Okay, now I'm just curious as to why that change was made and what real effect it was going to have in the broader picture. Thanks very much. That's all I have.
The only question I've got, William, relates to the, as I understood you to say that you were looking at really 3 different types of NPSs, and one of those you didn't mention was the NPS on the coastal area, where the approach taken in relation to Indigenous biological diversity at policy 11 is to distinguish between avoiding adverse effects on what you could generally summarise, although there's 6 clauses to it, as being significant natural areas or areas that were under threat. And then the approach then taken in the hierarchy under that, particularly NZCPS, is that as B, avoid significant adverse effects and avoid remedy or mitigate other adverse effects on, and then it gives a list of what could be more broadly described as the other Indigenous biological diversity. Did you look at that or consider that type of hierarchy?
I didn't look at the the NPS coastal policy statement, but that's interesting that the rest of the only significant is the first step, and the lower lesser effects are the ones that make their way through the pathway. I didn't look at that one, so that's new to me and quite interesting.
Right. All right. Thank you for that. It's just I wondered whether you'd turned your mind to it. Thank you. And that concludes your appearance. Thank you.
Thanks. See ya.
Right. Bye.
I've got Steve Tuck from Silverfin Farms online if we want to hear from him now before lunch.
Yeah, nice one.
You're reading the bonus today. Good point.
I'm well, thanks. Good morning.
So we're, I think, just about ready to go with you. Just hold on a moment. Yes, we're in your hands. Thank you.
Okay, thank you. So good morning to everybody. I'll say up front, I think what I'm about to present in terms of my summary of evidence probably echoes a lot of what you've already heard over the last day and a half. So the panel's already heard evidence from planners and ecologists about the ecology chapter, Silverfin Farms' concerns about the chapter, and section 8 of my statement of evidence just raise similar questions and echo similar concerns. So just to recap, Silverfin Farms' core concerns about this chapter revolve around the potential issues that will arise from using Appendix 2 of the pORPS to define significant natural areas, and the subsequent requirement under policy P3 that new activities and SNAs must avoid all adverse effects. echoing the concerns that other people have raised, Silver Fern Farms considers that the thresholds set in Appendix 2 for ecological significance are probably too low, and that when those thresholds are combined with the no effects approach in policy P3 for new activities, the provisions raise a prospect that areas with little ecological value will be protected as having SNA status, and activities that could produce environmental improvements like upgrades of industrial plants or just generic land stewardship, land management activities like weed clearance and weed management, those activities could be prevented from proceeding if the activity has any effect on an SNA as classified under the current notified provisions. In the scenario of the proposed ecology provisions, you can imagine that Appendix 2 criterion D1, for example, the rarity criterion, could produce an SNA classification, as could criterion G3 for ecological context. I mean, these are areas that support an Indigenous threatened species, or areas that are important for Indigenous fauna during some part of their life cycle, whether regularly or irregularly. Using the example of a large rural industrial facility like Silver Fern Farms' Finnegan site, you can envisage that there are going to be operational and commercial implications arising if SNA classifications end up inadvertently intersecting working areas like exotic shelter belts or structures or areas of managed landscaping, or areas that are, for example, consented and managed for discharges. I just point out that rural industry wouldn't be able to access the consenting pathway for specific activities under policy P4. That policy P4 obviously only provides a confined consenting pathway for specific activities. So as such, rural industry like Silver Fern Farms' site would be subject to Eco P3 and the avoid all adverse effects paradigm that sets up. And for existing activities in SNAs that are defined under Appendix 2, you've got some provision for minor upgrades under policy P5, but minor upgrades is where the line is drawn. Just echoing again concerns raised by other submitters, based on the Ecology Joint Witness Statement from the 31st of March, the Appendix 2 criteria are both untested and clearly they're problematic for a number of reasons. In my evidence at paragraphs 8.5 to 8.8, just as an example, I've recalled a recent SNA classification exercise that was undertaken in the Far North District. That exercise indicated that 42% of the district could qualify as an SNA under the criteria they used. As a result of the widespread concerns that such extensive SNA coverage could result in unreasonable restrictions on land use if operationalised in the district plan, the Far North District Council didn't operationalise the SNAs that it had identified. And I'm just providing that example, not to say that an RPS and a district plan are the same thing, but really just to illustrate the problems that can arise if unsatisfactory SNA provisions are pursued. And in particular, just emphasising that in the case of the Far North District, they tested and consulted on those provisions before they took them further. From what I understand from the Joint Witness Statement, and it's raised in Silver Fern Farms' submissions in my evidence as well, the proposed SNA classification provisions in Appendix 2 haven't even been tested. So that really, to me, sends a strong message that we need to be very cautious in operationalising these provisions in their current form. That's probably emphasised by the Ecology Joint Witness Statement, where they indicate significant reservations among the experts about the appropriateness of the criteria. Paragraphs 8.9 to 8.12 of my evidence traverse some concerns about the management of areas outside of SNAs under policy Eco P6 and the issue of a threshold or gateway for biodiversity offsetting to be allowable or forbidden as a management tool under Appendix 3. I noted in paragraph 8.11 of my evidence that in restricting biodiversity offsetting as a management tool, Appendix 3 is probably going to result in some opportunity costs in the form of foregone ecological improvements that would otherwise accrue as a result of biodiversity offsetting. In paragraphs 8.10.3 and 8.12.3 of my evidence, I also just noted the concern that others have already traversed in detail about whether, in light of RMA section 1041AB, Appendix 3 can properly introduce a gateway test to restrict when biodiversity offsetting is available as a management tool. On that point, I agree with other submitters. It would be more appropriate and potentially lead to better ecological outcomes if Appendix 3 set out some principles for biodiversity offsetting to guide decision-making about the sufficiency of an offset, rather than the current formulation where Appendix 3 is curtailing the circumstances in which offsetting can be considered at all. That's my summary of a statement of evidence, and I'll be happy to answer any questions.
Thank you, Mr. Tuck. Commissioner Sullivan, please.
Yeah, thank you. I'm just interested that before I get onto your evidence, you stated there that that you think the Appendix 2 criteria haven't been tested, and you thought that the joint witness statement indicated significant reservations. I suppose we've had the evidence we had yesterday. We had some saying there was general agreement and some saying there were some disagreements, but none of the ecologists who were involved have indicated significant reservations about Appendix 2. And my understanding is that a lot of those criteria have been around for quite a long time, and although ecologists have, you know, some disagreements about how they should be applied, I'm just wondering if you can back your statement up a little bit there, or if you've got anything that you'd like to add.
Yeah, probably to use an example, which I think comes up in the joint witness statement, where I think all of the ecologists agreed, for example, and this is probably really pertinent to rural industry operations, is the example of an SNA classification applying in situations where highly mobile threatened species are present, like birds or bats or lizards. There's a note in the joint witness statement to the effect that there needs to be further thought given to that particular issue. And that's a really good example of, I guess, a concern that Silver Fern Farms holds, that if the temporary presence of highly mobile threatened species is to be taken as warranting FNA status, and then that is compounded by the restrictive settings of policy P3, then it would seem that, using again the Finnegan site as an example, that if there are patches of landscaping, or if there are patches even that need to undergo weed management, but there are threatened species there, then that qualifies as an SNA. I think a witness statement was pointing to that issues like that within the. I don't think it was a case of the joint witness statement saying no, we've never seen these kind of provisions before. It's more a case of understanding that the threshold that the Appendix 2 criteria sets in combination with policy P3 is really problematic, and that was what I took to be, in reading through the joint witness statement, some significant reservations from the ecologists about how this would all work.
Yeah, and I think that point you've raised there is something that has come up, and it came up again from Dr. Keesing this morning around, you know, the example of a Korea ray or a New Zealand falcon in a pine forest. Yeah,
I missed one, but that's a great example, and I've heard of other examples of, for example, of native bats roosting in eucalyptus trees.
Yeah. Just turning to your evidence. I suppose you're reasonably critical of SNAs, and I'm sure you're not the only one there. But you do suggest possibly that you know, voluntary rather than regulatory management may be a more appropriate approach. If we were going to head down that route, how much confidence do you think that we'd have that the objectives of the RPS would be met?
Well, I'll back up a step. I wouldn't want to be characterised as being critical of SNAs. I think the difficulty is that the combination of the provisions is such that it's not a case of applying an appropriately cascaded policy framework in the context of assessment criteria that results in an appropriately tiered hierarchy of management. I think the concern is more that this appears to be a formulation that's going to result in a lot of land, speaking from a non-ecological expert point of view, being inadvertently classed as SNA, and then very heavy restrictions being placed on it. That's the criticism I'm leveling, rather than a criticism of SNAs per se. Your point about voluntary action. Now, I suggested that as one potential option, and I intended that to be as a suite of management responses. I don't think that voluntary measures are the silver bullet. But for example, I'd also just adding to that, just thinking through, there are obviously examples in policies and other regional policy statements where voluntary management, voluntary responses and Indigenous management measures are encouraged in policy. And I'll point to, for example, the Bay of Plenty policy statement and the Northern policy statement in that regard.
Yeah, okay. No, I mean, we did hear Dr. Keesing was a little bit critical around some voluntary approaches, and he seems to favour offsetting if we want to get out.
Agree. And again, that probably, I'm just echoing what other people have said again, is that turning to Appendix 3, this is the concern about the gateway test for biodiversity offsetting, and that it appears that you're really potentially giving rise to a big opportunity cost there to actually get what we all want, which is better environmental outcomes by precluding offsetting.
Mm. Yeah. Okay, no, thank you for that.
Yeah, thank you. I think Ian traversed the issues that I was going to discuss with you, but just on that joint witness statement, there is a, so on page 2, General Matters 3, they've clearly said that the first 4 criteria have been around a long time and are well tested and are generally considered good practice with respect to terrestrial as opposed to marine and freshwater.
Yes.
Yeah, I think the issue is around how they're applied, and what you referred to, I think, is in 5C. They're talking about a guidance document.
Yes.
Required, particularly around those mobile species things.
I'd also point to 5E as another area where there's some ambiguity that clearly these experts are saying, what does this actually mean and how's it going to work?
Yeah. Yeah, and that's where the concern lies that you're raised about how far will this go. And you talk about your consenting pathways there, identifying P4 as really only applying to a very narrow band of activities that might have to operate in an S&A.
Yep.
And then you've got P6 that applies to all other activities. And do you have a solution for that? Are you suggesting that perhaps the pathway in P4 should apply to all activities, and then there should be, as I think Ms. Mead suggested, a lower, not necessarily an effects hierarchy approach for other activities and for other Indigenous biodiversity that's not SNA?
I didn't catch the other submitter that you just referred to, but I think regardless, boiling this back down to the bare basics, what I think is really needed is a set of assessment criteria that are appropriately focused and targeted to ensure that SNAs capture what they should capture, which in my understanding is really the best of the best, and that there is then a cascading policy approach whereby you might have a carve out as there is under policy 4 for regionally significant infrastructure and the like, and that's fine. But ultimately what there needs to be is a cascading approach that ensures that the heavier avoidance type provisions are not applied in a wide ranging kind of ad hoc manner. I think the policy approach needs to be, like I said before, tiered or cascading or hierarchical in such a way that protection and avoidance of everything is reserved for those values that really warrant it, and that subsequently there is room to move in terms of avoid, remedy, mitigate, offset for those areas of ecological value that are less at risk or have less value.
Yeah, okay, yeah. I think that's, yeah, it was Miss Mead for Fulton Hogan suggesting a similar sort of approach. So thanks for that.
No problem.
I'm not sure whether you, or given that answer that you made to Mr. Cubitt, you may not have heard the question that I put to Ms. Mead. I take it at the end.
No, I would have missed it. I think I was.
That's right. That's right. So I want to ask you as well. Did you look at the New Zealand Coastal Policy Statement as to the way in which its hierarchy dealt with significant issues as being an avoid, but with the lesser categories, if you can put it that way, the hierarchy being to avoid serious adverse effects. Did you look at that type of hierarchy?
I didn't specifically look at the NZCPS, but I appreciate what you're saying about the avoidance threshold being reserved for significant adverse effects, potentially on those areas of significant value. And there's a vaguely similar formulation.
Can I just cut across you there? The hierarchy in the New Zealand Coastal Policy Statement is an avoid of any effects on the significant issues. And then the next level of protection is to avoid serious adverse effects on the other levels.
Haven't got it in front of me. Was the first level avoid adverse effects on significant species? Was that right?
That's correct. Yeah. With the next level,
I'm just trying to recall.
The next level down being avoid serious adverse effects on the balance of the ecology.
And that's certainly one way of formulating it, but again, without the document in front of me, and it's been a little while since I've needed to look at the NZCPS, but the framework that you seem to be suggesting under the first step, avoid all adverse effects on significant values. I mean, I can immediately see that you're going to need a carve out for those regionally significant infrastructure activities because they have those locational constraints. The next level down of avoid significant adverse effects on all other values, I would suggest that there needs to be another tier underneath that of it's for all other values that aren't quote unquote significant. It's not just avoid, there also needs to be a management, the availability of a management response, which is remedial, mitigate or offset and the like.
Right, yeah. Yeah, no, look, thank you for that, Mr. Tuck. That's the only question that I want to raise with you, so your evidence otherwise is very clear. Thank you.
Thank you very much. Have a good afternoon. Bye-bye.
That's it. Okay. We'll break for lunch.
You got the last minute ones?
Yeah, we'll break for lunch till 1 o'clock.
That's cool.
Thank you. Got it. Welcome, and Dunedin City Council. So who's taking the role? Paul, all right.
Good afternoon, Paul Freeland, Principal Policy Advisor to the City Development, the DCC. Unfortunately, we don't have any legal counsel with us today, but we'll just set out what we intend to do. Today I have with me Zoe Lunnis, our Biodiversity Advisor of the Council, and Katie James from our policy planners. I'll get them to introduce themselves, but essentially Zoe will just talk a little bit about her involvement in the expert witness conferencing, and then Katie's prepared a short brief of evidence which she'll read, and we're happy to take questions as we go.
Thank you.
Kia ora, I'm Zoe. So I attended the expert conferencing on the 31st of March, and with my agreements or where I sit with what is currently proposed / the different options. My initials next to it, so I'm happy to answer any questions if you have any for me.
Kia ora everyone, my name's Katie James. Would you like me to read through my brief evidence?
Yes.
Yeah. I will start from paragraph 6 on the scope of this evidence. So Mr. Freeland submitted on behalf of the DCC, and I agree with the evidence submitted by Mr. Freeland in relation to the ecosystems and Indigenous biodiversity topic in his evidence. My evidence expands on 4 of these points. So the first of these is definition of occupancy. In relation to Eco 02, Mr. Freeland in paragraph 29 of this evidence submits that the definition of occupancy needs greater clarity. The proposed definition means the number of sites occupied in Otago. I agree with Mr. Freeland that it's unclear what the word site refers to in this context. Mr. Freeland suggested an alternative definition which reads, means in relation to measuring Indigenous biodiversity, the number of units per area across the species range that is occupied by the species. I've also sought advice from Zoe Lunnis, Biodiversity Advisor at the DCC. I consider it helpful to include the qualifier in relation to measuring Indigenous biodiversity as recommended by Mr. Freeland. I recommend slightly different wording for the second part of the definition, as on further consideration, the use of across a species range may be unclear. A suggested alternative would be to refer to the number of units per area occupied by a species or taxa. In this way, the definition signals the methodology used to measure occupancy without it being necessary to define site. And the second point is on APP 5 and Eco P9, wild and species. So in relation to APP 5, species prone to wild and conifer spread, and Eco P9, wild and conifers, the DCC submitted on APP 5 requesting a review of the species listed in relation to ecological evidence specific to Otago. In Mr. Freeland's evidence on this topic, he notes that there are a number of tree species not listed in APP 5, which are managed through the 2GP as they are prone to wilding. He also asked for a reconsideration of whether it is necessary for regional and district plans to control species that are managed under the Biosecurity Act, such as Pinus contorta. In relation to the latter, Mr. Freeland's evidence includes a note to plan users from the 2GP, which sets out other requirements outside the plan. This is by way of an example. Moving on to paragraph 12, in his evidence, Mr. Freeland proposes amending APP 5 to include boxthorn, hawthorn, rowan, and sycamore, and to delete Pinus contorta, and recommends consequential changes to Eco P9 to replace the word conifers with trees to provide with the non-conifer species. He also proposes adding small woodlots as well as permanent forests as other forms of planting where wilding species should be avoided. This would support the management of wilding species for planting shelter belts and small woodlots as well as forestry, which is defined in the 2GP as including plantation and permanent forests. The 2GP includes boxthorn, hawthorn, rowan and sycamore, along with 6 conifer species in Rule 10.3.4 tree species. Under this rule, forestry and shelter belts and small woodlots must not include any of these species. My understanding is that the trees included in Rule 10.3.4 were based on Dr. Calvin Lloyd's evidence for the 2GP Natural Environment hearing, specifically in relation to the Dunedin district. I understand also that there will be other tree species that have a higher invasive risk in other parts of the region. I'm not aware of any specific response to DCC's submission in relation to APB5. However, the Section 42 author's brief of supplementary evidence for the Eco chapter discusses the proposed use of trees instead of conifers, along with whether Eco P9 should be amended to include Tauka ecosystems in paras 27 to 28. I won't read my way through those 2 paragraphs, but going to paragraph 15, without having seen an alternative drafting for the policy or new definition for wilding trees or the legal advice referred to, I'm unclear on the reason for not recommending broadening the policy and management of wilding trees. This term would encompass wilding conifers as well as other trees. And I also note that the Section 42 version of Eco 09 has been broadened to cover permanent forests, which are not themselves currently subject to the NESPF. I note that in paragraph 349 of the original 42A report, in relation to submissions from other submitters, the author states that the purpose of Eco P9 is to protect Otago's Indigenous biodiversity from wilding conifers, not the full suite of invasive tree species. I consider that it is desirable for the RPS to contain policy direction to manage the effects of a broader range of wilding tree species on Indigenous biodiversity and to add the tree species listed above to APB5. I also support Mr. Freeland's suggestion of adding small woodlots or similar to Eco P9 in order to broaden the policy to the management of smaller areas of tree planting, including shelter belts. APB2, significance criteria for Indigenous biodiversity. Mr. Freeland's evidence supports the amendments recommended to APB2. I note that there has been expert conferencing involving ecological experts to discuss the criteria. DCC's biodiversity advisor, Zoe Linnis, has attended the conferencing on behalf of the DCC, and her views on the issues discussed, recorded in the joint witness statement. And finally, Mr. Freeland notes in his evidence in Para 49 that the Section 42A recommendation to accept the DCC submission was not carried through to drafting. His proposed solution, which I'm in agreement with, is to amend as follows, and that's replacing enduring with maintained in perpetuity. Thank you.
Maybe questions to any one of you, I think. So if I ask Bianca to commence.
Yeah, no, thank you. And yeah, that's been helpful. I think it's covered off some of the things that I had noted against your evidence, Mr. Freeland. One of the things I was just sort of thinking about through this is in terms of the Biosecurity Act versus, I suppose, what's been potentially regulated through the RMA processes that we've got here. I mean, I'm assuming the focus on the plant species or the tree species you're looking at are the ones that would commonly be planted as part of woodlots or forests. You wouldn't ever, in a plan, would you ever go beyond that into the sorts of species that people are planting in their gardens or that sort of thing that are listed under the Biosecurity Act? And I suppose I'm just kind of thinking, where's the line when we're talking about pest plants in terms of what what's sort of been picked up through the RMA that's potentially having, impacts. I'm thinking more sort of garden plants that people plant in their garden and then escape out into the neighbouring reserve and off they go.
Is that something, Zoe, you could comment on in terms of the pest plants?
Yes. So I guess in regard to pest plants, I think for DCC, it's making sure that we cover our bases for what could potentially be used, given that we would like to have kind of the smaller woodlots and planting areas that may use species that aren't on this list. I do agree that the Biosecurity Act should cover those, but I think there's clarity in making sure that that's known through this policy. That's my view on it. I don't know if you have anything.
Look, there is a tension here. We obviously, through our district plan and other district plans within the region, have a list of pest plants which are wild and conifers and are managed in rural environments and not just necessarily SNAs. And I guess it's unusual for a local authority or anybody to come to a regional policy statement process and ask for greater controls. But I just think it would be helpful if there was some regional perspective on this and a basis for supporting, even if it's down at a district level, controls which are wider than just wild and conifers. And even though it may be at a district level, by their wilding nature, they're likely to go across the boundaries and be a regional issue anyhow. And I think the chair was talking about certain plants which he'd seen in rural environments through Central Otago, for instance, which are clearly an issue in terms of protecting Indigenous biodiversity. So just see it as a useful thing to just maybe stretch and be a little bit more aspirational in this space. And we're a little bit confused by the belief that the NESPF put some sort of constraint on the amount of controls that you can actually have in this area.
Yeah. And I suppose part of the question is when you're looking at your district plan, where do you draw the line between what pest plants you're going to include and regulate and which ones you don't, given that I think, the wild and conifers and the others that you mentioned here are probably a reasonably small group of what would be region-wide pest plants.
And I guess in this instance, in terms of the 2GP, the district plan for Dunedin, we took advice from Calvin Lloyd in terms of what he thought were the main ones actually to be cognizant of. Naturally, there's any manner of plants which could be planted in domestic gardens on a rural property, which you might have concerns about, but they presumably aren't ones which he believes as an ecologist need to be managed through a plan per se. But you're right, I mean, there is a line to be drawn. We got expert advice through that hearing, and that's probably where we would draw the line.
Okay. That's helpful. One of the questions I had around Eco P9 was subsection 1 in that policy is talking about avoiding planting, replanting, etc., within areas either identified as SNAs or buffer zones adjacent to SNAs, and then other initiatives as well. Do you think that's enough? That we're just talking around SNAs and we're not talking about, potentially other areas as well where they could spread? And I know we haven't quite got to the landscape chapter yet. Maybe it's picked up there as well, but all land and fresh water. But
yeah, you'll see in my evidence that we have concerns around the definition of SNAs and whether they've been identified or not, the delay in identifying those areas, and for that reason alone, and we struggle with the NESPF in that regard as well. But for that reason alone, we would be open to them being managed outside of SNAs, because they may well be ultimately in an SNA, but for a major piece of research and work to identify all these areas, you run the risk of them being inhabited by or invaded by these pest species.
I think Ron's mentioned the wilding pines he observed in the Mackenzie Basin recently, and I know Craigie Burn, there's a lot of control going on, but it's quite disturbing how fast they get away. If you put a buffer zone in place around this, it could, when you think there's still potentially going to get away and affect significant areas within a reasonably short space of time.
Yeah, and that's why I think controlling them throughout the rural environment, is a much better response. It means you lessen the risk, and if you set that signal through the RPS, that would enable district plans and local authorities being more confident about taking that sort of approach.
I think I do have a point there as well. Under the NESPF, the wilding, anything planted in forestry should already be controlled within an SNA. So the effect that we're seeing, I don't think is through policy, it's through people not following the policy that's already in place within the NESPF.
No, I think that's all the questions I have. Thank you very much.
Yeah, thank you. So just a couple of quick ones really. In terms of your suggested changes to the occupancy, I'm still not clear what the number of units per area means.
Yeah, that was something we were sort of
Yeah.
working with. It's a suggestion. It's trying to get at the fact that using the word site is could be potentially confusing given the definition of site and other aspects. And also it's trying to get at the sort of the way that you would be measuring occupancy. So certainly accept it might not be the best wording, but just sort of an attempt to try and be a bit more specific about what it means.
So are you thinking in terms of a numerical measure of plants or density or
So it would differ depending on what you're measuring.
Yeah.
And I'm not an ecologist, so sort of only skimmed the basics of this. I'm not sure if Zoe could add
Zoe,
anything to that.
how do you understand that to work?
Yeah, so my understanding was that occupancy was to be used as a measure, a way to understand how we're enhancing, the extent and occupancy. Yeah. So the extent being the range of the species and how that looks as a whole, and occupancy being more around the density of those species within an area.
Yeah.
That was my understanding from it in that kind of ecological sense. So for me, the inclusion of it being in the definition to include some type of measuring seems right, and I think we all agree it's a bit sticky in terms of how do you identify an area and a site. Does that mean population, ecological district, region, the habitat? So that I think still needs to be pulled out, but within the 2GP and how we define site, and I think for a lot of different pieces of legislation as well, there is room for that maybe to get a little bit tangled, but yeah.
Yeah, I think what you said you actually probably enhance that definition is probably an alternative there to combine some of those things into that definition so we understand in each context what it may mean. Well, while you're talking, Zoe, I didn't realise that that you would be turning up today, and I see you're the ZL in the JWS. And there's been a lot of debate about that, which is kind of interesting given this thing's been around for a long, long time. You weren't in the group that suggested or seemed to think that there was a low significance. Are the criteria here similar to what's in the DCC plan? Or is it the same?
It's pretty similar. It's not the same word for word, but again, I think that kind of national policy, the national criteria that we see in the MPSIB and through different regions and different city councils is pretty similar. I would say there are some aspects that are word to word with the DCC criterion, but yes, it fits very closely with what we manage through our 2DP.
Is there a difference in terms of a regional document dealing with this to what a district plan might deal with, or should it be the same? Because these debates between the ecologists around how a lot of those things should be measured. Should it be nationally or regionally, or just regionally, ecological district, all that debate. What's your view on that?
Yeah, I think that really depends on what you're measuring, and I think that that's been pulled through by how we've reasoned through different criteria on whether that would be measured at a national scale, ecological district, or at a regional scale. So there are changes in here that I agree with, and I just would find, I guess, in terms of with distinctiveness, I guess is a big one, with the removal of within Otago or nationally. With the distributional limits being nationally, that would be recognised as a regional limit as well, if it's reached a limit within Otago nationally. So I think it's captured there. I think that capturing it within Otago does give the potential for you to capture a lot of things that could be considered SNAs. So yeah, your question is, I think that I don't think there will ever be, you can't refer to everything being assessed either regionally or an ecological district or nationally. I think it needs to be considered per criterion.
Yeah, so as what you said earlier, I think you were saying you need to keep a bit of flexibility in there around, depending on what you're assessing, what extent or spatial extent you apply, whether it be national, because we know some things in Otago where they might be nationally at risk or red or threatened or whatever, but they're not yet.
Yes.
So that gives you the flexibility to actually say, well, we don't have to worry about that in a Otago sense. Is that what you're saying?
Yes, yeah, definitely. There's a number of species that we have here that are strongholds, and it doesn't mean that we should be able to do whatever we want with them, but it's been thoughtful about how you identify an area of significance and whether that lowers the threshold to a point where you would capture a lot of things that may not specifically meet significance criteria in terms of their abundance regionally.
So, and that's the issue that's been raised by a lot of people, that the threshold's too low.
Yes.
And just listening to you speak is about, so we have the RPS criteria, but does that necessarily translate into a district plan? Because of what you've said, there is flexibility in there. The district plan process may not actually be that low. You have that ability to.
Yeah, I think, can you answer that, how it would translate more to?
So depending on how it's couched in the regional policy statement and as to what regard we have to have to actually give the district plan, that would dictate it. But largely, if the regional policy statement says this is the way it has to be, then obviously you have little choice as a council. And I've heard a lot through this hearing and previous ones about we'll leave that to the district plan, and we'll be able to do that at the district plan level. And gosh, I hope there's some real clarity as to what you're leaving to the district plan level and what you're putting in the regional policy statement, because
the same argument.
I've probably said it before to this panel, but if you leave things in the regional policy statement without any wiggle room for council, then council will have no choice as to what they're doing. And so if there's not flexibility, or if you leave stuff which is at a local level couched in the regional sort of terms, that's going to be difficult for us as a council. But I think in this respect, largely, and could be wrong, but if the values are right at the regional level, that'll be a minimum for the local level. We of course will reserve the right to actually add to that, much in the way we do at the moment with wilding trees.
And possibly landscapes.
Yeah, same.
The only other thing was in relation to Appendix 4, where that your change hadn't been carried through into the compensation bit. It has been put to us that we should be adopting the principles for offsetting and compensation. I think these are out of the well, I'm confused now. It's either the freshwater management MPS or the exposure draft of the
Look, and I think one of the opening statements in my evidence originally was that wouldn't it be great if the MPSIB was out, and if there was a national direction, obviously we prefer that rather than arguing what the words should be on every matter around the various regions of the council, so of the country. So if there is a preference for a national approach, whether it be the freshwater management or the MPSIB, we'd be comfortable with that.
Yeah, because that talks about preferably in perpetuity, but the words before that talk about at least as long as the impact. I'm assuming if you're offsetting or compensating, that's because that's gone. So it's going to be in perpetuity, isn't it?
Makes sense to me.
Yeah, I'm trying to envisage a situation where in those small occurrences where you'd be using offsetting or compensation, where there'd be no longer an impact. And I can't actually think of one. I don't know if you guys have ever come across that. Because then the perpetuity thing ends up being an issue with how you condition that long term when the company's gone and the activity's gone.
We don't have a lot of experience in terms of offsetting through our plan. It's obviously provided for now, but what you're saying resonates.
There's a little bit of McRae's creeping into DCC. Yeah. So has it been used in your consents there?
Yes, it has.
Yeah.
We work with Waitaki District Council and DCC as kind of a package, but there's a big kind of compensation in addition to an array of other conditions. Compensation being in terms of funding for biodiversity in and around McRae's district, but there's also a lot of other things that they have to do for offsetting. And yeah, it is something we've done. That's a huge scale operation.
There's a suggestion from Oceana that the way the RPS currently set up is that those options may not be able to occur because of the limits in the principles are seen as criterion that you have to meet. There's certain limits in there that they can't meet, so they're not going to be able to use that. Is that how you read it?
My understanding is if you're able to meet one, then you kind of have to do that, and then you move through the threshold. So if there's the potential for it not to get to compensation, then that's how it's done. That might halt them from doing the activity that they're wanting to do in that particular area.
Well,
That's my
suggesting when they get the compensation, the limits within how that's worded effectively stops them from being able to use that provision and flicks them back to the void.
Yeah, that's my understanding of how it would work, and I guess in that sense the whole reason for that policy is the avoidance of massive these big activities that would cause a huge amount of loss of biodiversity, something that we've seen occur for many years. And yes, it's slow, but I guess we're at the point where there needs to be a line where we say we can't actually afford to lose any more if we're not able to offset it in a way that's manageable for our species. That's my understanding.
Okay, thank you for that.
I just have one frivolous question, really. That's about these the word wilding trees as opposed to conifers. Is that generally the way they describe these things?
So that was the quick and dirty amendment which we thought could expand the number of the types of trees that would be controlled through these types of provisions. Currently, wilding conifers is the expression used in the NESPF, and typically it's been the term which has been used for all wilding trees, but it is actually a particular types of trees, and so.
It needs to be called wilding pine at once.
Absolutely, they did. Yeah, so it's just an evolution of the terminology, and we've already wanted to evolve slightly further.
Okay.
Yeah,
that's the only question I had. Thank you.
Just on that issue, and just looking at the fact that really what Eco P9 is addressing is the planting of plantation forests and permanent forests. And then you're suggesting inclusion of rowans, boxthorn, what else was it, hawthorn. I mean, those types of things, and sycamores. I think, if we take the boxthorns and the hawthorn, you would hope that nobody would, some amazing idiot would ever contemplate plantation forest of those. But if you look at rowan or sycamore, are those realistically planted as paragraph P9 as plantation forests or permanent forests?
Just note that we recommended adding small woodlots, I think it was, to and shelter bits. So our plan is also to manage these in terms of shelter belts and small woodlots. So just to capture that, sometimes people might plant these other species.
Right. If you can help me with the wilding calculator, the wilding, whatever it's called in the NESF.
Someone who knows the NESF, it's a bit of a nightmare, really.
Well, the definition is just appalling. Definition is a wilding tree risk calculator means the document DSS1, quote, calculating wilding spread risk for new plantings, close quote, in appendix 1 of the document referred to in item 2 of schedule 2, guidelines for the use of decision support system calculating wilding spread risk for new plantings as used in conjunction with those guidelines. Couldn't imagine a worse definition. And then when you look at appendix 2, all it gives you is some website references. Am I reading that right?
Sounds pretty much right to me, but well, that was correct though.
And then the NESF at regulation 11 says a wilding tree risk calculator score must be applied to land, etc., etc. Have you seen one of these things done?
I haven't certainly.
I've seen a completed one. I haven't seen the process that it entails, but I know there's a number of different things about kind of the area that you're planting in, different wind directions, how strong the wind is, and the possibility for spread to occur in those different areas. But it has to be completed by, I think it's a forestry or suitably qualified expert that knows how to assess those things. That's not something I'm on top of. I have seen one and they just appear to be numbers down the page, and then they cut that total, and if you're under the threshold, then you're good to go to plant whatever. Yeah.
And then strangely, regulation 11.5 says all wilding conifers resulting from their forestation activity must be eradicated at least every 5 years after afforestation. We're established in, and I can't quite follow this because it says we're established in wetlands or significant natural areas. So it's only controlling wilding spread in wetlands and natural areas. So general spread is not, you're not required to control.
Yeah, the NESPF has a lot of issues, and I think reliance on it obviously have to you have to have regard to it, and you've got to give effect to it, and it is what it is. But reliance on it is somewhat problematic because it is almost indecipherable. It's not well, I don't think it's well monitored or enforced. I mean, I think cyclone up north and slash management, which is also in the NSPF, will come into view as to we've got these policies and this complicated national environmental standard. It's just not working, and I guess it takes us back a little bit to trying to understand why there's some belief that the NSPF constrains what the regional council can put in its regional policy statement. Because I think
basically that'll come because of the statement that afforestation is a permitted activity if regulations, then you get 10, 11, 12, 13, 14 are complied with. So you've got all these incredibly poorly drafted provisions, which you've got to somehow satisfy yourself that they can comply with. I mean, that will provide a permitted activity standard.
as you've identified, it's for specific activities, plantation forestry, and it's for those activities within that activity in particular locations like SNA, and it's for particular types of trees being, wilding conifers rather than other trees which have wilding properties. And so it's quite, while it's enabling for the plantation forestry industry and it puts some controls in place which look on paper to be very good, it's really quite a narrow sort of focus at times. And this latest consultation which they've had on it to try and talk about permanent forestry and battles between the plantation forestry or commercial forestry operators and the permanent forestry people and how that's going to play out is interesting as well. But trying to work out what an SNA is and whether it has to be documented and be one or just have the values that make it one, it's really, really complicated.
Mm. So plantation forestry is defined as being forest deliberately established for commercial purposes. How's that being interpreted, in respect of these carbon emission permanent forests?
I'll just say that they're not covered under the NSPF, so they're not currently subject to it. That's regulations.
And yet couldn't they argue that they are established for commercial purposes? Because they are being planted to gain an income year by year.
Yes, but you couldn't.
Nebulous credits.
It's the harvesting part of the, I'm trying to find the definition.
Sorry, it's the
fact that it's it has been planted and has or will be harvested and replanted. So,
where are you reading from? Yeah.
So that's the definition of plantation forestry in the NSPF.
Okay. Where's that word?
Sorry.
Oh, I see. Oh, yeah. And it has been, or will be harvested. Right. Yeah. Mm. Oh, thank you for that, because I'd overlooked that. Yeah. Mm. So this regional policy statement could very definitely, without question, because of that wording that you just draw attention to, have application to those carbon credit permanent forests.
Yes, I guess the current wording has included permanent forests, and I guess that's what it's already broader than the NSPF.
Right. Yeah.
It's perhaps anticipating what the outcome may be of the recent consultation on the NSPF, much the way that you might use Indigenous biodiversity stuff, which hasn't come to fruition yet, but there's drafts around, and there's a belief as to how it might play out.
What do you feel about the? I haven't looked at whether there are submissions on it. I'm not sure if there are. But what do you feel about subclause 2 to policy 9, which is just supporting initiatives to control existing conflicts and limit their further spread.
I mean, it is enabling in a sense, but it's not actually providing, strong direction as to what should be done.
Because it's an urgent problem.
It really is, yeah. And as I say, anyone who thinks that the NSDF is doing anything tangible, like as you say, you can drive through the Mackenzie or many places around New Zealand and see that it's a problem.
I mean, I last drove through Mackenzie country about 3 or 4 years ago, but I was staggered last month to drive through there. Just see a sea of wildlings that are about yay high, but they're on the verge of taking over. Okay, thank you very much. Oh, sorry, Zoe, there was one other issue that I wanted to just ask your thoughts on. I noticed it in the JWS, I noticed it, and there's been quite some emphasis yesterday on all the paragraph 5 on page 3, on all the excerpts agreeing that a guidance document for interpretation of the wording that was used by you all would be essential. Now, is that, I take it that's reflective, really, of correct me if I'm wrong, reflective of the frustration you all feel that you've got different views.
Not so much different views. I think it was making sure that no matter if it was an ecologist that was in the room or anybody picking up this criteria to use, that it would be ensured that it was used the way it was intended to through this process. So there was a lot of, while we were trying to figure out little nitty-gritty bits of wording, that when you take a step back as an ecologist who's coming in to do an assessment in the field, going to understand the difference between an or and an and or some other word, if we've got some type of guidance about how we apply and what it looks like, at what scales we're measuring things, that's going to add a lot of clarity to criteria, which can seem just a lot if you're looking at it as a piece of paper to take up with you in the field to do the field-based survey, which is essentially what it is. So yeah, it's that guidance about how you apply it when you're out there and what it means and scales that you work at. But yeah, it came up through the Canterbury Regional Policy Statement that has one that offers a really good kind of backbone about how we apply it. And I think through the discussions that we had, there were a lot of things where maybe one person might think it would be applied that way, and it was highlighting where we need that clarity.
We need consistency.
Yeah, consistency and clarity throughout it. So yeah, I agree. I think it's incredibly important, and yeah, any way to help ensure that it's understood.
Does DCC have such a guideline, or
no, we do not have a guideline. Right. It would be great if we had a guideline.
Right.
Would you have the heading little nitty gritty words?
We could do. I think we could do.
All right. Thank you very much.
Thank you.
Thank you.
Wild trees.
Good afternoon. Katie Ross.
Kia ora, good afternoon.
Thank you. We're in your hands. Thank you.
My name is Katie Russell. I'm here on behalf of the Queenstown Lakes District Council, and I'm happy to take my evidence in chief as read, and I'm happy to answer any questions you might have.
Anything in particular that you wanted to emphasise before we turn to that?
No.
No, okay, thank you. Commissioner Sullivan.
Questions here. I don't know. Have you, oops, what's going on? Have you been listening into the Dunedin City Council presentation?
I listened into a portion of it, but not the full thing, unfortunately.
Yeah, because I think there's some of the issues you're raising around P9 overlap quite a lot with what we've been hearing from Dunedin City Council. They've requested that wilding conifers refers to wilding trees. We've had a good discussion around the NES for plantation forestry and how that links in. And I'm just looking at yeah. So you haven't seen the amendments that they were requesting?
Unfortunately, no, I'm sorry. But yeah, wilding conifers are obviously a challenge for our district, and anything that that helps us all get to the end of it would be great.
Yeah. So they were asking for plantation forests and permanent forests and Eco P9 subsection 1 to be brought in to also include woodlots and shelter belts as well. Is that something you'd be supportive of?
I'd like to look at how it was drafted, but I am concerned about that type of planting and how it has the potential for unintended consequences, particularly in a landscape context.
Yeah, okay. Yeah. No, thank you. I think that was quite clear from your evidence. Thank you.
No questions from me.
I really just want to talk to you about paragraph 3.4 of your evidence, which is where you were seeking that really permanent forests became defined, as I understood what you were saying there, as being carbon forests or forests established for carbon offsets. And I just wondered whether you ever encountered this sort of situation. That I know I was involved in a case about 10 years ago up in the High Court in Marlborough, where somebody, believe it or not, against a background where there'd been about $2 million spent in poisoning wilding pines throughout the Marlborough Sounds, was refusing to allow clearing of mature pines on his property on the basis that it was a tourist attraction and that he had a tourism venture in mind where people would pay money to come and wander amongst these beautiful mature pines. Is that sort of concept likely to undermine what you're suggesting in paragraph 3.4? And is it the sort of thing, I'm sort of thinking about the Hammond Springs area. I'm not as familiar with Queenstown, but in Hammond Springs, there's quite a lot of emphasis often placed on walking through the deciduous forests around Hammond Springs, and that sort of argument. So you could be, what you're seeking, I'm just worried about 3.4 could be self-defeating.
I am open to sort of your broader experience because those are both great examples. I guess when I looked at permanent forests, I didn't know immediately what that meant. And that to me means that a layperson user wouldn't either. And people have large swaths of land and opportunity to plant as they see fit, more or less. So anything we can do to clarify what a permanent forest looks like and how that's managed or not is what I was seeking.
Right. And in your area, trees like sycamores, rowans, are they on your list of spread trees?
I'm just referring right now, I'm looking at our wilding exotic trees chapter, which is chapter 34 of the district plan. And there's a long list, including sycamore on it, for prohibited plants.
Right. And rowan?
Let me just check. Rowan doesn't appear to be on the list.
Tony, yes.
Sorry, I didn't quite hear what you were asking.
Cotoneaster, was that the,
Pineasta.
no, Cotoneaster.
Cotonia. Yeah, Cotonia is, yes.
Yeah.
I'm happy to provide 34.4.2 to you, to the hearing administrator, if that would be helpful.
Yeah, look, it would be. Thank you.
Yeah. Okay, I will send that once I'm off.
All right. And I think that's all that I had to ask you. So thank you very much for your appearance today. Thank you.
Thank you for having me.
So come. Well, I recognised you when I saw you pointing to someone else.
I was just checking the order. So my relevant section of my evidence is section 6, starting at page 21 to 23. I'm happy to take it as read. I've just, as a summary, evidence is basically about policy Eco P6, which you've heard a lot about in the effects management hierarchy. Just putting forward that I consider that the effects management hierarchy for Indigenous biodiversity should be phrased in a manner consistent with what is in the exposure draft, but also in the MPS freshwater management and also international best practice. It's about having a stepped process, avoiding adverse effects where practicable, then moving on to minimise where practicable, remedy where practicable, and where there's more than minor residual effects, then having a pathway through offsetting and compensation. So my drafting at paragraph 6.2 reflects the exposure draft of the MPS IB. I don't consider it's inconsistent with the MPS freshwater management.
Thank you.
No, I think they're pretty similar, aren't they? Yeah.
The exposure draft of the MPS IB does use the word demonstrate. If you have to demonstrate.
Yeah.
That's about the main difference.
The only question really actually comes around Raymond's down your infrastructure and are you ever likely to come into contact with SNAs, because that's a different process than P6 and it's very constrained to, there has been a drive from Frontier and Co to include regional, important regional industry and the list of things that should be given a gateway through various things. Is it an issue for Romansdown?
It won't be in Otago for its Dunedin works, more likely than not. And we didn't submit on any of the SNA sort of provisions of this. Ravensdown shareholders may have issues in terms of being farmers, but it's not something we covered in the submission.
Okay, that's all. I'm just clarifying. Thank you, because your image is pretty clear. Reflects quite a few other people's here.
I'm aware of that.
Thank you.
Okay.
I just had a query, and it's just in general query, really. Does the change of wording from mitigated to minimised cause you any concerns?
No. The use of avoid, minimise, then remedy is consistent with what's in the MPS freshwater management and their effects.
Yeah, it is, but of course it changes the word mitigated in the Act to minimise. And do you see any difference or any cause for concern about that?
No, I'm not concerned about. I see minimise is to do your best to reduce effects as far as possible.
Thank you very much. Thank you for attending today. Thank you. First bound we've heard from, so we're at Waka Kote.
She's just gone to log in now.
Okay.
It's a teacher, isn't it?
Good afternoon.
Good afternoon, and thank you for coming on screen for us. So the position is that we're in your hands as to whether there's particular aspects of your evidence you want to emphasise for us today. So I'll leave it up to you. Okay.
Fantastic. I'm just going to put my headset on. I just can't quite hear you as clearly as I'd like to. Bear with me one moment.
Right.
I do have some additional points that I'd like to take the time to clarify because we have had a number of experts ahead of me. So it would be useful.
Is that a bit better?
Oh, fantastic. Can you hear me?
Yes, we can indeed. Thank you.
Brilliant. Okay. So I have prepared a few written notes that I would like to walk through and then invite questions. Is that okay?
Yes, indeed.
Fantastic.
Yes, indeed.
Okay, so back to the polite proceedings. My name is Letitia Jarrett. I'm presenting for Waka Kotahi on this chapter, and I have provided my primary evidence, which I hope you all have a copy of.
Yes, we do.
Brilliant. Okay. I would like to make a small correction. In the evidence that was circulated, I had left a comment box in there, and I apologise. There was some annotated notes from a colleague who'd done a review. So I hope that wasn't too distracting.
You don't need to apologise for that. I wish all the evidence was like that so that we can make it exciting. So thank you.
So I'd like to summarise the outstanding matters that I have, which are 4 key matters, and I will scoot through them reasonably quickly, trying not to add too much extra information, given that I am one of the last experts. Just like to reiterate that Chapter 10 is important to Waka Kotahi, and direct the commissioners back to Mr. Robinson's evidence, who explains Waka Kotahi's role and responsibilities as the road controlling authority and how important the parts of our network that traverse the sensitive environment are. He also mentioned that it is necessary for our significant infrastructure to remain resilient and adaptive for climate change, whether it be a large project or minor safety improvements. I'd just like to clarify that Mr. Robinson won't be giving evidence today. Now to the more substantive part of my evidence, and you have heard from a number of other experts today, so we'll attempt to be brief. The effects management hierarchy as set out in Eco P6, I believe still requires amendment. I have listened to some of the suggestions, and I remain of the view that the edits within my primary evidence are still necessary to ensure that Council has the discretion to be able to consider functional and operational need of infrastructure being located at particular locations
and the effects on ecology balanced against the effects on safety, adaptation to climate change, and the need for infrastructure in those locations. I also acknowledge here that other experts have also discussed the inclusion of practicable within Eco P6, and that this wording, practicable, has also been included in clause 13(2)(c) of the exposure draft of the National Policy Statement for Indigenous Biodiversity. I believe that the wording change is necessary to ensure the balanced evaluation of effects as intended within the provisions of Part 2. I'd also like to draw the committee's attention to clauses 4 and 5 of Eco P6, where I've included consideration of Appendix 3 and 4. This again is to enable council and decision makers to have discretion when considering resource consent applications and notices of requirement, rather than being required to ensure that all activities are in explicit accordance with these appendices. My third point is in regards to the limitations within the significant natural areas that it places on our linear infrastructure. And I refer now to Eco P7. This is a small departure to my evidence as written and has arisen out of the coastal chapter discussions. There was significant conversation around the taoka and how they would be best addressed. I have had discussions with my colleague Sarah Ho, who presented evidence on this section, and have reconsidered my position. I think it's best that when dealing with SNAs and taoka, that they should be wholly addressed within the eco chapter. And I offer some wording changes to address the issues raised in the statement, and recommend the deletion of CE P5 1 G to H within the coastal chapter, and for Eco P3, Eco P4, Eco P5 and Eco P6 to apply within the coastal environment. Consequently, this will result in the words outside the coastal environment being removed. I can table that if it's easier for the commissioners, but I would like to scoot through the next couple of points regarding Appendix 2, 3 and 4. I acknowledge that Appendix 2 has had significant conversations occurring, and I have considered the joint witness statement dated the 31st of March 2023. I support this advice and put forward that has been put forward under general matters point 5, and support the advice given that a guidance document would help. It's been my experience working on infrastructure projects that better outcomes can be achieved when applicants are able to design, assess and consent works within a clear assessment framework, which enables offsetting and compensation to be used. In regards to general matter point 6, relating to information or data on which to base evaluations, there was a comment made noting that expert judgment is required. There is a significant amount of ground truthing that occurs within the projects that I have worked on, being nationally significant or regionally significant infrastructure. And without having agreed baseline data and or methodologies, then it can result in excessively a lot of expert witness caucusing which can become quite difficult for the planners on both sides to work through. If an agreed methodology isn't found, then you can get right through to a consent hearing, and the commissioners have to work through which is or isn't appropriate. I think that if the council were to have agreed information and baselining included within the RPS, that would alleviate a lot of those concerns and provide certainty. Moving on to Appendix 3. In regards to my views expressed in Section 9 of my primary evidence, I remain concerned that the drafting as proposed doesn't adequately enable a clear pathway for nationally and regionally significant infrastructure to provide for biodiversity offsetting and compensation. So I'm concerned that Eco P6 isn't workable. I note that the commissioners have asked a number of questions of Mrs. Hunter, who gave evidence for Contact Energy and Manawa regarding mapping of NSAs and the application of Appendix 3. I agree that the current drafting of Eco P6 and the implementation would direct applicants back to the avoid requirement, making the current drafting impossible to apply in practice. I refer commissioners back to my suggestions to amend clause 4 and 5 of Eco P6, which would enable council staff to consider the appendices rather than apply them in whole. As discussed by other experts already and noted by the Otago Regional Council, Eco P6 is intended to provide for nationally significant infrastructure. However, the provisions within Appendix 3 and 4 are in effect to prevent this from occurring. As linear infrastructure, it is difficult or impossible to avoid areas completely. It is necessary for infrastructure which is limited in location to be able to work within areas of SNA or significant natural areas. I, as a professional, do not support the loss of ecological values and agree that no net loss is appropriate. And to achieve this, offsetting and compensation for linear infrastructure is necessary and practical. As discussed in my primary evidence, sections 9.3 and 9.7, I believe the removal of the recommended sections would enable practical consideration of these appendices. In regards to Appendix 3, I believe that Clause 1 is too restrictive and directs us back to avoid preventing the consideration of works within ecosystems and offsetting of the impacts that may be created. If one piece of threatened species was found, we would be prevented from undertaking work at all, rather than being enabled to consider what the impact of those effects are and if offsetting and/or compensation could be provided. In regards to Clause 2E of Appendix 3, I believe this requirement is excessive and difficult to provide within the timeframes of the RMA consenting provisions. In regards to Clause 2H of Appendix 3, I consider this to be inconsistent with the requirements put forward in 2E for in perpetuity provisions to be made for offsetting. In regards to Clause 2F of Appendix 3, this assessment seems unnecessary because the offsetting process would otherwise remedy or mitigate these effects described. Lastly, I'm nearly finished. In regards to Appendix 4, I again think that Clause 1 is excessively restrictive and directs us back to avoiding and potentially prevents the consideration of works within ecosystems and compensation of the impacts. in regards to clause 2D of Appendix 4. It's possible for positive outcomes of compensation to be enduring. However, we need to consider how we can enable practicable management, and the use of enduring is concerning and requires deletion. In regards to clause 2F of Appendix 4, I again note that clause D and F would potentially contradict each other. My primary concern regarding Appendix 3 and 4 remains that it prevents the applicants and decision makers from implementing EcoP6. That concludes my summary of key points and my evidence. And while I acknowledge a number of people have already spoken to these points, I'm happy to take questions that the committee may have.
Thank you. There may well be. Do you have a typed copy of what you've just been reading?
I can send it through to Kate, the hearings administrator, now, if that's useful.
Yes, if you would. Thank you. And Commissioner Sullivan, questions?
Yeah, no, thank you. And thank you for your evidence as well. We have heard a lot of, had quite a lot of evidence around Appendix 3 and 4. And discussion around whether they should remain as criteria versus principles, which I didn't really see something in your, didn't see specifically mentioned in your evidence, but do you have a view on that? Or do you see that there's much of a difference there? And I suppose referring to, for example, the MPSIB exposure draft, I think the MPSFM was also principles rather than criteria.
So just to clarify the question, so you're asking me if I have an opinion over whether criteria or principles would be more appropriate for Appendix 3 and 4. Have I understood?
Yes, that's correct.
Okay.
You put it a lot more succinctly than I did.
I had time to listen. I don't think that either of those would resolve the concerns that I've raised in regards to the clauses within 2. I think we have Appendix 2, which provides us with a clear approach, which is accepted throughout the country, as we've heard a number of the experts already say. That does provide us with some guidance. My outstanding concern with Appendix 3 and 4 remains that as they stand with the current writing, they don't allow us to enable EcoP6. I think the key change, which would be useful, is the inclusion of where practicable and consideration of Appendix 3 and 4 in clauses 4 and 5. It'll give us the opportunity to have experts discuss and consider what is and isn't appropriate.
Thank you. And I suppose, you know, we've heard from Contact Energy and Manawa and now yourselves as well, who do come under the EcoP4. Do you think in relation to EcoP6, and this is something that's come up as well, that there needs to be a different bar for significant infrastructure versus other activities in relation to, you know, say, for example, EcoP6? Should there be an easier way through for significant infrastructure? And if, is that something that you've thought about? Because I suppose some of what's, you know, what we're hearing from the likes of yourselves and Contact Manawa and the like, who would come under that EcoP4 and our significant infrastructure. I suppose, is it reasonable for there to be a different test? Because I think if, you know, potentially if some of the changes that you're requesting were made, that would that would potentially open the gates to a lot of other activities as well, which may, could potentially mean that we're not delivering on the objectives here. Is that something you've got a comment on?
So I would direct the commissioners back to the exposure draft of the NPSRB, which does have an provision, I think it's clause 311, which allows for significant infrastructure as a particular pathway for providers such as ourselves. I would be comfortable with a pathway similar, not exactly the same. We're still talking about the wording of that one, but yeah, if there was a pathway that enabled nationally and regionally significant infrastructure, yes, I would.
Because my understanding of the exposure draft of the NPSIB too is that clause 3.11 would still require you to have consideration of the effects management hierarchy, which there are, for offsetting and compensation, there's still a bottom line of a void there if offsetting and compensation can't be done adequately. So this, I suppose I sort of look at the NPSIB and I think, well, there are some wording differences in there that could make a material difference, but it still does have a void as a backstop there.
It does, yep. I think, as you noted, the exposure draft in its current draft, and in my update that I received yesterday, there are outstanding issues which are still being worked on. There may be people more learned than me that are able to talk to that more succinctly. So I'll just note that there are additional draftings and concerns that have been raised by various people. I think so doubling back to your earlier question, would it be appropriate for there to be a provision for nationally significant infrastructure within the RPS? Yes, I think that would be appropriate. And I acknowledge what you said, the comments you made earlier, that there would be, potentially it would open the gates for everyone. I think the fact that we are nationally significant and that our infrastructure is linear and we don't always have the options available to locate in other areas and still maintain the level of service that we've committed to providing and are directed to provide. We have to be enabled to meet those commitments, and a provision for nationally significant infrastructure would allow that to happen. Did I take too long answering the question and lose the points for you?
No, that was good. Thank you. I'll leave it at that. Thanks very much.
Thank you.
Thank you. I think your concerns are pretty clear. They do reflect a lot of other people's that we've heard from. But the only thing I was going to add to what Bianca was talking to you about or asked about was in relation to your paragraphs 9.4 down to 9.7, and I'm kind of struggling to understand the concern around the requirement for offsetting your compensation to be in perpetuity, given particularly the nature of your infrastructure, which is probably going to be in place forever, unless it's flooded, if it's in the coast. So I'm just trying to understand why that's an issue for you. Is that more around the management of it in the future, or I'm struggling to understand why it's an issue.
So my concerns relate to my expertise as a planning professional and the measures and controls that we have available to us within the RMA. The RMA has timeframes. Resource consent applications have limitations. In perpetuity exceeds the timeframes for a normal 35-year resource consent application. And often the obligations for in perpetuity may go beyond the active work Waka Kotahi is undertaking. And if, to take an example like the flooding that you mentioned earlier, if a requirement to retreat is put in place and we have to move away from that particular route, or the road slipped out and it no longer exists there, there would still be an in perpetuity requirement for Waka Kotahi to maintain an offset or a compensation where there is no linear infrastructure any longer. So it's that type of future complication for assets.
I understand that now. Yeah. Although I guess there you're focusing on regional council consents, because assuming generally you designate state highway alignments, and there'd be land use consents, that would probably be where the offsetting and compensation would be attached to, because it's more of a land use effect. Fair, or are there other examples where that may be used?
Generally, yeah, offsetting and compensation can occur within the regional council requirements also. And we're seeing more and more that the works that we undertake within designations do necessitate earthworks, discharge, and impact water, air, and land. So there are situations where we do have to offset or compensate for resource consent applications issued by regional councils.
Okay, thank you. I think that's all I have actually, because you've touched on all the other key issues, so thank you for that.
I've got one issue to just ask you about, and that is whether it was purposefully done or not, I'm not sure, but in paragraph 7.5 in your recommended wording, the sequence of that you've got is avoid, then then remedy where practicable, and then mitigate it where practicable, and that reverses the order in the NPSIP draft, which is avoid, minimize. They use the word minimize, and then use remedy. Was that purposeful, that change? And if so, why?
So in discussions and working through the options we had available, we tried not to make too many changes to the existing drafting. So we've worked within the framework that Eco P6 provides, so that our recommended changes were minor, but created the intended change that we needed to seek relief. So yes, as stated, it's intended for it to cascade as described. Does that answer the question, or was there?
Yeah, no,
B?
It does. Thank you. I'd taken from your evidence and what you've said orally before that you've tried to, in essence, replicate those parts of the draft NPSIV, and that draft had changed that sequence, whereas what you're saying is that whilst you did take some aspects of the NPSIV, in reality you tried not to interfere too much with the drafting of the proposed RPS. Yeah.
Correct.
That's explicable. Thank you very much, and thank you for the appearance this afternoon. Thank you.
Thank you, Mr.
That concludes today. we're not expecting you. Sir? No, thank you.
Camera. Get it over and done.
In that case, we're finished now until tomorrow at 9 o'clock.